Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. God hear, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Peter Sachs. To my right is Justice Joseph Ditkoff. To my left, Justice Robert Toone will be your panel for all 6 cases this morning. I want to extend a special welcome to the summer interns from the Committee for Public Counsel Services. We're glad you're here, and we hope you find this morning's arguments educational. We've got 6 cases. We'll hear 3, and then we'll take a break between the 3rd and the 4th case, which we should reach right around, the break should be right around 11 o'clock. We'll take a 15-minute break at that time and then come back. So for all counsel and parties who are arguing, we have read your briefs. We have read the relevant parts of the record. We're familiar with your arguments. And so I would just urge everyone to get right to the heart of your argument. We don't need a factual or procedural background. Generally, if we have questions about that, we'll ask you. 15 minutes goes very quickly, so please just cut to the heart of your argument, and we'll cut right in with the questions that we have. So with that, I will call the first case, which is a partially impounded case, 23P867, Commonwealth versus Alberto SOTO. Mr. Zindrowski.
Yes, thank you. Good morning. May it please the Court, I'm here today on behalf of Alberto SOTO. And so this appeal concerns, I think, one issue, whether Mr. SOTO would have pled guilty to OUI second, but for now inadmissible breathalyzer test. And
can I ask you, I know the microphone stretch up towards you, but yeah, anything you can do.
Yeah, okay.
Thank you.
Lean over here.
But he pled to OUI first as a lesser of second. Is that not right? He didn't plead to OUI first as a lesser of second?
I thought he pled to OUI second, but I could be mistaken. But I think this was in the line of the Ananias and now Hallinan breathalyzer cases where the breathalyzer is now deemed inadmissible, but at the time Mr. SOTO had pled guilty, it was admissible. Mr. SOTO blew a .14 at the station. And so I think what makes this case a little special and differentiates it is that Mr. SOTO had a viable defense that he had diabetes and that this medical condition contributed to both his mental confusion at the scene and his inability to perform field sobriety tests. And so diabetes itself is a condition that can mimic intoxication. And so this can go to some of his mental confusion regarding the mental field sobriety tests or his inability to figure out his car registration. And then the diabetes also leads to deleterious physical effects where he has, we have medical records introduced as part of the motion for new trial and his affidavit, which state that he was feeling some of the physical effects of diabetes, that he was having neuropathy and he was feeling mobility gait impairment is in his physical therapy notes where he...
Let me ask you something about that. I saw that the defendant in his affidavit said he had diabetes at the time, and you include some medical records, but they all seem to be from much later than the plea. And I didn't see anything that said anything about his condition back in 2012. Did I miss it?
No, the medical records were what I could find from 2021. But it is worth noting that Mr. SOTO himself did let the arresting officer know that he had diabetes, or I think the arresting officer asked. But that evidence was present at the time of the arrest that he was suffering from diabetes. And so a few years later, it's
So
developed.
one further question about the diabetes.
Sure.
Your brief says that diabetes can not only mimic the signs of intoxication, but can also produce acetone, which may interfere with proper operation of the breathalyzer. Why wouldn't, if that's a strong defense, why wouldn't he have asserted it at the time, even though he didn't know that the breathalyzer result might be very suspect because of the OAT issues?
Right. Well, I think that the breathalyzer is still the crown jewel, where that's just one possible slight avenue of defense where it doesn't really go to the rest of the case, which I think there's certainly some evidence of intoxication aside from that breathalyzer number. And so I think that being able to challenge both of those would sort of be the tipping point towards him taking that case to trial and challenging those observations, the arresting officer's observations.
You say that the breathalyzer result is the crown jewel of the Commonwealth's case here.
Yeah.
I know that was the case in Hallinan, but this case seems to be a good bit stronger than Hallinan in terms of the length of the interaction between the police and your client. The fact that your client said he'd had 6 beers, there was a beer spilled in the front seat, I gather, and he said he was on the way to get more. And he, on the way to the police station, while in the cruiser, he said to the officer, please don't arrest me, just beat me up and drop me off at home, which seems like pretty good consciousness of guilt evidence. So maybe the breathalyzer is a crown jewel in any case, but there are many jewels here, and I just wonder how strong this case would have been if it had been taken to trial. And didn't he get a pretty good deal for 6 months concurrent on his 2 OUIs that he pled to?
Right. Well, I think that essentially it's that defense that he had that sort of mitigates a lot of the difference between this and Hallinan, where he had a legitimate and I'll call it viable defense of that diabetes that was brought out at the time. And so this would have been something that could have defended against the case. So there was something on his side, so to speak, and that would explain a lot of those indications of intoxication. He was having mental confusion because of the diabetes. And so I think that is sort of what lets me argue that breathalyzer result is still the crown jewel here. And I think it still goes to the deal he made that included the other case. It still goes to that, where this is now a case that has that unassailable breathalyzer result number. And so I think that is still hanging over his head and inducing him to plead guilty.
So what happens if we agree with you and allow him to withdraw his plea to the second of the 2 offenses to which he pleaded guilty? You're not asking us to disturb the plea to the first one?
No.
So what do we do? Remand for resentencing? I mean, there were concurrent sentences, but can we assume the judge would have done the same on that case if this one had not pled out?
I think
or how do we handle that?
I think it's a good question. I would think that it would be remanded for to withdraw the guilty plea on this alone, but I'm not entirely sure. That would be my feeling off the top of my head here, that he would go back for a trial, if possible, on this OUI, not disturbing the OUI drugs. I think if there are no further questions, I can rest on my brief.
I have one question. I noticed in the defendant's affidavit, he says he's had a difficult time finding employment and am restricted to employment along bus routes. Why is that?
Because as a result, he lost his license as a result of the pleading guilty. So sort of
for how? Forever? Forever?
Not forever, but in the immediate aftermath of the.
Oh, I see. That means he had trouble back then. Okay, yeah, that makes sense.
Yeah, so his, kind of all the different negative effects he had from his pleading guilty, as I argue, as a result of that
I get it.
Improper breathalyzer test.
One question I had, a factual question. Both you and the Commonwealth refer in your briefs to the defendant being ordered to serve his sentence at Howard Street, or at least asking that it be served there? I mean, I'm not sure how the judge could order that, but what is Howard Street? Is that some kind of facility run by the sheriff that's less, perhaps less difficult to navigate than a house of correction, or?
That would be my understanding, but I'm an appellate practitioner for the most part, so I think my brother would be able to answer that more definitively than me, but that would be my understanding.
Okay, so that was another part of the relatively favorable deal that he received.
I think, though, he still did receive the 6 months incarcerated there. So.
Is it fair to say, based on his record, which went back quite a ways, including a quaff to an OUI in 1997, but that he didn't have much committed time previously and that he kept offending, that 6 months was better than one could expect after a guilty verdict?
I think that possibly, but I think that given he would be going to trial, I think the goal would be to raise a viable defense in the hopes of winning and not avoiding the jail sentence altogether would be, I think, what he was looking at doing back in 2013.
Okay.
Okay. If there are no further questions, I would rest.
All right. Thank you. Thank you for your argument. We'll hear from Mr. Lynch for the Commonwealth. And just for the benefit of those observing today, if you see us looking down at something on our on the bench up here, like a screen, we're not checking the baseball scores. It has all the briefs and the record materials. So that's why we're glancing to the side. All right, Mr. Lynch.
Thank you. May it please the Court. Travis Lynch for the Commonwealth. Just to address some of the factual questions, I believe that he did plead the OUI second. So we're not saying that he got a charge concession on that point.
Thank you. I must have misread that.
Right. The drugs, the OUI drugs, was charged as a first offense, even though the prior was, I believe, a continuance without finding several years before. I'm not sure why that one was charged as a first offense and this one was a second, but that's what happened here. Howard Street is, as I understand it, it's a treatment. The sheriff runs a treatment facility there. So the Commonwealth recommended that the defendant go to Howard Street or be recommended to be sent there. That point is he needed drug and alcohol treatment, which I hope he got when he was there. But so that's part of the disposition. And so I don't know factually if it's easier to serve a sentence there than at the actual jail, but it was for treatment purposes. On the question of what would you do hypothetically if you reversed in this case, the sentence on the 2012 case is fully executed. I don't think you could resentence it. It's an interesting question, but I don't think you could as to the 2012 case. So the motion judge in this case was the plea judge as well, so he had familiarity with the case. Even though this case was decided before Hallinan came down, he nevertheless applied the correct standard. He found that the evidence against defendant on an impairment theory was still overwhelming, even without the breathalyzer evidence. He specifically discredited the defendant's assertion or suggestion that he would have gone to trial. So in that respect, the case is completely different from Hallinan, because in the Hallinan case, the motion judge credited the defendant's assertion that she would have gone to trial if she had known that the breath test was inadmissible.
There was no evidentiary hearing, correct?
That's correct.
So do we owe any deference to the motion judge's assessment of the credibility of the affidavit?
It appears as though you do, because that's exactly what happened in Hallinan. There wasn't an evidentiary hearing in Hallinan either, but on appeal, the SJC applied the abuse of discretion standard as opposed to, they didn't actually de novo review the motion judge's credibility determinations on the papers in Hallinan.
Was the motion judge the trial judge in Hallinan?
In Hallinan, no. The motion judge was not the plea judge. In Hallinan...
I'm sorry, the plea judge.
Right.
I don't mean the trial judge. Yeah.
Right. So, but even though the motion judge in Hallinan was not the plea judge, the SJC still chose to defer to the credibility determination on the papers, which seems interesting, but that's what the SJC did in that case. I think
Why is it a credibility determination? I mean, it just seems that it's an assessment of the strength of the Commonwealth's case once you take the breathalyzer evidence out. What assessment of credibility is going on here, as opposed to sort of the evidence is really strong, or maybe it's not so strong once you take this piece away? I just don't understand the credibility piece to this.
I mean, there's case law that says the motion judge in a 30B motion can just reject as self-serving a defendant's statement on the papers, which seems to be a credibility determination.
Okay. But it necessarily falls on the strength of the evidence that's left, don't you think?
Here,
I just don't know what else. What else is a motion judge assessing when it comes to?
I think in this case, it's both the strength of the evidence and also the favorable disposition that the defendant received.
Okay.
So,
And he says he would have gone to trial,
right,
and the motion judge didn't credit that.
that's correct.
Yeah.
I mean, it's kind of a funny thing. We pretend that the plea judge remembers the plea and remembers what the defendant looked like, where with a sort of vanilla OUI plea, that seems really unlikely, don't you think?
It is interesting that that's how we do this, but that is what the case law states. I mean, this plea happened, I believe this motion was in 2022, and the plea, I believe, was in 2013. I mean, I have no idea how anyone would actually remember that, but that's what the standard of review is. We recite that over and over again in our case law, that we defer to the motion judge's determination if he was the plea judge. So, but I agree with you, it is interesting, but that is what we do.
How
So-
much weight should we give to the plea counsel's affidavit? Whereas you point out in your brief here, it wasn't particularly strong. I think it said the information may have affected my advice, as opposed to I would have counseled the defendant to proceed to trial. But again, how much weight should that be given in the analysis of determining whether or not the plea should be undone?
I guess I could say, in comparison with Hallinan, in Hallinan, the attorney was much more specific, and he said, if I had known that the breath test wasn't coming in, I would have advised this defendant specifically to go to trial. And the defendant in that case said, the Hallinan defendant herself said, I would have followed my attorney's advice. So in this case, it's both the vagueness of this attorney's averment, plus the fact that defendant says nothing about how he would have weighed the attorney's advice. So I would say that this attorney's affidavit, I mean, if he had been more specific and said, I would have advised him to go to trial, then we might have something more to talk about. But he didn't say that. He didn't say that at all. And the defendant doesn't say anything about relying on anyone's advice. He just makes a conclusory statement that he would have gone to trial.
I mean, where there's no ineffective assistance claim, does it matter?
It does, because part of the analysis here is what advice the defendant had from counsel. So it's not actually that the lawyer is ineffective. It's in light of what the lawyer knew, what did the lawyer tell the defendant? So no one's saying that this attorney gave subpar representation. But obviously his advice might have been affected by the admissibility of the breath test evidence. But he didn't really say it that specifically.
And are you asking us to treat that as the attorney's candid assessment of the case? And he says might have because he couldn't bring himself to say would have, because you're suggesting he thought that the case was strong and the benefit of the plea was significant? Or what are we supposed to take from that? What are we supposed to take from the attorneys not saying I would have advised him to go to trial?
I think the simple answer is it shows that defendant didn't carry his burden of proof. I don't know what else to say other than the attorney didn't really say much at all. Unless there's any additional questions, I'd ask that you affirm. Thank you.
None? Thank you. Thank you both for your arguments. All right, our second case, another partially impounded case, 23P 930, Commonwealth versus Alphonso J. Sinclair, Jr.
May it please the court.
Mr. Studlar? Yep.
Carl Studler for Alphonso Sinclair. So assuming for the sake of argument that the April 14th, 2020 missed call from Mr. Sinclair's, the number listed as his to the complaining witness's phone, assume that there was enough for that to be authenticated, it's still, the Commonwealth still didn't meet its higher burden to prove beyond a reasonable doubt that the April 14th missed call was actually made by the defendant from his physical phone as opposed to being spoofed. The Commonwealth's witness, the complaining witness, describes spoofing the ability to use an application to send either text messages or phone calls from a number not belonging to that individual making it. So the evidence was sufficient to show that Mr. Sinclair could have made the April 14th call displayed on the complaining witness's phone, but there was no reliable evidence establishing his authorship. Nothing about that ephemeral event of the auto-rejected call linked it to Mr. Sinclair. This was not a case where there were multiple calls. It was a singular missed call. It wasn't call after call after call. There were no follow-up. There were no text messages either from Mr. Sinclair's number or from other mysterious numbers that same day. So that was, in light of the fact that there was that was the scenario, that there was just a singular missed call, and that there were no phone records introduced, a potential source.
You're kind of leaving out all the many other communications purportedly from your client.
Sorry, I didn't
You're
catch
kind
that
of leaving, I'm
first.
sorry, the air conditioning is barely keeping up and it's very loud. You're kind of leaving out all the other communications purportedly from your client in determining whether this one was from your client as well.
Thank you, Your Honor. Yes, I believe in that, with response to that, it doesn't make sense for all the other counts, the counts corresponding to text messages from unrecognized numbers. The trial judge acquitted my client of those counts, showing that he didn't believe there was reliable evidence of authorship of those communications, again, all from unrecognized numbers. So in light of...
Why does that matter? When you determine a sufficiency question, you ask whether any reasonable trier of fact could find it, not whether you yourself find it. So for sufficiency purposes, doesn't the judge have to, assuming that there is sufficient evidence, treat them as facts?
I'm not sure that that's the case, Your Honor. I mean, I think Your Honor's point is taken about they could have been admitted and passed the bar of that there was enough to support a finding by a fact finder, that the defendant authored at least some of them by a preponderance of the evidence. But my argument is that there needs to be even more in the way of confirming circumstances to get beyond, to show that my client actually made the call than there is for the authentication piece. And there's one case I would like to call to the court's attention. I did not mention in my brief. I just came across this case yesterday. I emailed opposing counsel about it. The case is Commonwealth versus McMahon, 97 Mass Appellate Court, 2020. So I'd like to
Sorry,
comment.
what was the second site? You gave the year 2020, but what's the page site?
Oh, I'm sorry, Your Honor. I don't have the I don't believe I have the, I think actually 560, 560.
Okay, and what's the name of the defendant?
McMahon in this case.
McMahon?
Yes.
Okay, thank you.
So I'd ask to, I'd like to mention this briefly and also submit a post-hearing letter to the court. If the court
What does McMahon say?
So in McMahon, what happened is this was a case where there was a singular message from that defendant sent from an account that was not undeniably his Instagram account that had his picture on it, and that he had his username, which the victim recognized, and that he and the victim had communicated on Instagram before, and during a time when the restraining order was active, she received a singular message that just said, yo, coming from his Instagram account. But this court found that there wasn't enough evidence to find that the defendant was the author of the message on the beyond a reasonable doubt standard. They didn't decide, they didn't address, or this court declined to address whether the message was authenticated, but they said whether it was or not, there wasn't enough to meet the higher beyond a reasonable doubt standard that Instagram message was actually sent by the...
For authentication purposes, can we differentiate between a social media account or something that relies on the internet where you can essentially log in from anywhere if you have the credentials, and a cell phone which arguably could be presumed to be in the possession of the subscriber? So when you have a text that's a text, I suppose, which could be generated off of an iPad or an Instagram message or a DM on Facebook, anyone with credentials anywhere in the world could do that. But if it's a call from a phone, isn't it more likely that it's coming from the person who possesses the physical phone?
Your Honor, I would ask this court to treat, in light of the ability of people to use applications to spoof, which was set forth in the record, to basically make counterfeit phone calls, make phone calls from an application on a computer that appear to be from a number that they're not from. I'd ask this court to treat this case where the alleged victim here received a singular, on the count for which my client was convicted, a singular auto-rejected call from a number displayed as belonging to him, that to treat that like the Instagram message in McMahon, because just like an Instagram account may be able to access...
Well, it seems to me you're not arguing sufficiency and whether this one call was sufficient beyond a reasonable doubt. You're arguing whether it was properly authenticated. And the question there is whether the judge could find by a preponderance that the screenshot of the call was what it purported to be, which was a record of a call from your client. So, you know, despite the possibility of spoofing, and I'm not sure I saw evidence in the record about that, I just saw some argument or some speculation about it, is the fact that the screenshot showed a call from your client's phone number sufficient to find by a preponderance that the call came from your client's phone?
That's a good question, Your Honor.
Well, let me ask you this, why isn't it?
So, Your Honor, I would like to actually to take the same tack as the court did in McMahon, and that even let's say assuming for the sake of argument that's enough to authenticate it. It's still not enough to support beyond a reasonable doubt that it was actually made, the call was made by the defendant. The court in McMahon starts with the authentication cases and then says we're not going to decide whether this text message was authenticated, but it definitely doesn't meet the beyond a reasonable doubt standard where the level of corroboration required is higher than the mere preponderance standard.
Well, in that, when you're looking at the issue from a sufficiency lens, what exactly is the issue that you're saying? It wasn't established beyond a reasonable doubt that the defendant was the the author or the sender of the call? Is that the point?
Yes.
Because we can't talk about authenticity and say, oh, it has to be authentic beyond a reasonable doubt. It has to be some other term. So you're saying it wasn't proven beyond a reasonable doubt that the defendant sent the message.
So the only count on which he was convicted was the
Sent the call. Sent the auto reject call. Yes.
The missed phone call on April 14th.
Yes, yeah, that he sent that call. Is that what you're saying, that it's not established beyond a reasonable doubt that he sent that phone call?
Yes, both. The sufficiency argument has two aspects. One is it's not established beyond a reasonable doubt he actually made that call. And the second is that the Commonwealth did not introduce sufficient evidence to permit a finding beyond a reasonable doubt that he made it intentionally as opposed to accidentally.
Well, okay, so on the accident theory, right, there's no evidence suggesting that the defendant made an accidental call, right? And for the Commonwealth to have the burden to disprove accident beyond a reasonable doubt, there has to be some suggestion in the evidence that it was an accident for them to respond to, right? Isn't that?
Yes, Your Honor, the evidence has to raise the possibility of accident.
Right, and here there wasn't any reference in the transcript to accident until, I think, an argument made by defense counsel, but there wasn't any evidence that was raising it as a threshold issue.
So, Your Honor, I believe there was evidence that did raise it. That issue can be raised through the Commonwealth's case in chief. And in this case, just the fact it would be one thing if there was multiple missed calls from this number on multiple dates and there were text messages from that number or with content that was specific to the defendant, like near that date. That would be one scenario. But in this scenario, there was a singular missed call, and it was reasonable, as trial counsel argued, for the defendant to have the complaining witness number in his phone, even with the restraining order, because they had young children together. And he would also want to know, not mentioned by trial counsel, but I would say, like, he would want to know if someone who had a restraining order against you was calling, if nothing else, to avoid contact.
Well, there was, just to be clear, there was the one auto-rejected call, and then there are the two duo calls from the same phone, right? So there's a little bit more than just that. But I'm just not sure, even if it was just one auto-rejected call, is that enough to sort of raise the issue of accident to the extent that the Commonwealth now has an obligation to disprove it?
In this context of their relationship, when they're in a relationship for years, it'd be one thing if there would be no reason.
Well, of course. I think what you're saying is he's got her contact in his phone, but there was no actual evidence suggesting that this was an accident. It's just speculation, isn't it?
Your Honor, I believe it's not just speculation because it's speculation to the same extent that it's speculation that he made it intentionally, because that ephemeral event of the auto-rejected call.
Okay, but it's plausible that it was a pocket dial, but does the Commonwealth in its case have to negate every possible innocent explanation, even though there's no evidence to support that explanation? I mean, if the defendant said, I used to carry my phone in my hip pocket and it wouldn't lock sometimes, and yeah, I had a number of instances of pocket dialing people, that is evidence that arguably could put the burden on the Commonwealth to disprove accident. But there's no evidence. It's just counsel's argument. Hey, a pocket dial could happen. That's about all there is, isn't there?
Your Honor, I believe that falls within the realm of just common sense and common experience. Anyone who's had a cell phone has initiated calls by accident, whether it's a pocket dial, a misinterpreted voice command. So I believe that's something that can, that's really just general common experience.
So there's nothing particular to this case that suggests it was an accident? No evidence, it's just kind of common knowledge?
It's the evidence in this case is the fact that there was only one call.
How does that make it more likely than not? Or how does that make it more likely that it was a pocket dial? I'm not getting it.
So I think, Your Honor, it's because there weren't any calls from the defendant's number leading up to that or after that.
Well, except the two duo calls.
The duo calls the judge did not find the defendant guilty on those counts?
Right, because the judge may have been in doubt about whether they occurred on the dates that were charged. The April 15th date was just written in on the printed copy of the screenshot, but there's no suggestion the judge didn't believe that those duo calls came from the defendant's number, just the way that the auto-rejected call came from his number.
Yes, Your Honor, but if they'd come from the defendant's number at an point in time prior to the restraining order, they wouldn't be a violation. And that without the information of when they were made, the judge did not find him guilty of those counts. But my argument is here that there's nothing to support on sufficiency, there's nothing to support the inference. It's equally plausible that he made the call by accident, and that, or that.
Is that really true when you have someone who has his mother call and then picks up the phone while she's talking to him, has sent all these texts to the victim from all different numbers complaining about pictures of the kids and birthday parties? I mean, why don't we consider that in determining whether there was an accident?
I mean, I think that's assuming that the defendant did send those, and that, again, the evidence, the trial judge didn't find that, and the evidence wasn't sufficient to show that, to authenticate those, they were sent from unrecognized numbers and no information particular that only the defendant would know.
I have just one further question, which is the Alden case. In Alden, the wife's knowledge from, or witness's knowledge from past experience that a particular phone number was associated with the defendant sufficed to authenticate the text from that number as being from the defendant. How is that different from this case?
In that case, I don't have my only thought on that, Your Honor, is that there was content to those text messages, whereas the auto-rejected call, there was no content to support that it was actually the defendant who made it, no voice or anything.
All right, seeing no further questions, we thank you for your argument,
Thank
and
you, Your
we'll hear
Honor.
from the Commonwealth.
May it please the Court. ADHE Chile from Middlesex on behalf of the Commonwealth. This case, the evidence not only shows the defendant could have made the April 14, 2020 auto-rejected call. The evidence actually showed the defendant did. As Justice Ditkoff talked about earlier, this is not a case just about a single call. The defendant made 2 video calls the very next day that was rejected or declined. The defendant had texted the victim over 9 months, have specific reference to the children and his desire to see the children and his blame on the victim.
Yeah,
Isn't a problem, though, that you're trying to establish the authenticity of the April 14th auto-rejected call, and you're relying on text messages that themselves don't seem to be authenticated, right? So there's a little bit of a question of turtles all the way down, but you never get to something that's actually clearly establishing the defendant's identity here, other than perhaps the fact that the wife knew it was his phone number. So I guess that's the problem when you get to relying on the text messages, and there are some details in those text messages that suggest knowledge of the family, but those messages themselves don't seem to be authenticated.
So these messages, you have to look at them as a whole. It just shows the pattern that the sender, this is from the same sender that has a similar tone, similar desire to see the sender's children. And if you look at the way the text message is structured, you see the word there. Instead of saying T-H-E-I-R, it actually used the word T-H-E-R-E consistently throughout the messages. So not only the message shows, the content itself shows that it's from the same sender, it shows that the sender actually wants to see his 2 children, especially on Exhibit 6, where the sender referenced his child's 5-year birthday, and that is the birthday of the victim's and the defendant's child on that day. So if you look at the text messages as a whole, that shows that this comes from a same sender and it's from the defendant.
So, 9 months sounds pretty impressive, but I only count 7 text messages over 9 months, and one of them is the day before the phone call. But when it's that sporadic, how much confidence does that really give us that the call was intentional?
I agree, this limited text messages, but if you look at it, it's basically like 1 text a month, and the only month that's missing is from May to July, and that's the time when the defendant was not aware the RO was active against him because he was not present at the extension hearing. So if you look at these text messages and the content itself, it really shows that the defendant was the one that authored. And goes back to Justice Sachs' question earlier, even the April 14, 2020 screenshot itself will show that the defendant made that call past at least preponderance evidence, simply more likely than not. It was from the defendant's cell phone. There was testimony from the victim that the defendant had called her or texted her over 100 times. And the victim also testified that the defendant had that number around April 14, 2020. that phone call from the phone itself, the defendant's phone itself, shows more likely than not the defendant made that phone call from his home number.
There's no obviously there's no con to an auto-rejected phone call, right? So what are we confirming exactly? We're confirming that the defendant had an interest in making communications to the victim? Is that I mean, because it doesn't seem there to be anything more that we can connect between these other communications. Is that really an authenticity issue, or is that something else?
So authenticity really just shows that whether it was genuine, like whether the defendant actually sent those text messages, and that's more likely than not. After that, if you go to sufficiency, these messages shows a pattern of the defendant contacting the victim despite the RO.
Yeah, let's just stay on that authenticity for a second, though. I'm just trying to understand what is the authenticity inquiry here, because there's no content to an auto-rejected call. So what exactly are we relying on the other communications to establish with respect to that call?
So one thing is the screenshot itself shows that it comes from the defendant's cell phone. And like Justice Sachs said earlier, unlike social media where you have different access, phone has a physical access too. So that makes more likely compared to social media to have the defendant actually the one placing the call. And you have other evidence at trial that contextualize. This is a preliminary question, not a question for the trial of fact. So if you look at this evidence as a whole, that shows that the text messages contextualize the April 14, 2020 call, not only to show the defendant was the one who made that call, and the call also in turn contextualized everything. So if you look at all the evidence and screenshots all together, it will show a pattern of the defendant contacting the victim despite the RO, and that the call was not made by accident because he had an intention and a pattern of contacting the victim.
It seems like you have a stronger sufficiency case than you do an authenticity case, because I take your point that there is reason to surmise that the call was made given the other facts. It just sort of, if we take away the fact that the victim knew what the phone call was, I just don't quite understand the connection between these text messages from numbers that you didn't recognize and how you make the connection that we then conclude that the victim sent the auto-rejected phone call.
So looking at those text messages, it's not just from a spoof number. If you look at the content itself, those content shows that the defendant made those text messages because it's specific reference the sender's desire to see his children as
if someone is spoofing a number, they could also be spoofing the content in the sense that it could be someone other than the defendant who is, member of the defendant's family, just to speculate.
That is certainly a possibility, but we're talking about a more likely than not standard. And in this case, the messages did provide details of the victim's defendant's life. It was a specific child's 5-year birthday. Exhibit 6 actually contextualized the rest of the messages. And this, if you look at the content and the way that the text messages were structured, it was clear it's from the same person because it has the same tone, it has the same spelling of the text messages. And if we're talking about more likely than not, it's more likely than not the defendant authored these text messages and contextualized the call. And
do you need to rely on the other, the text messages from the other phone numbers to authenticate the one auto-rejected call?
it would make the authentication stronger, obviously, to use the text messages to contextualize the call. But on the call itself, because it's from the defendant's phone number, the victim knew the defendant had access to that phone. And
so if that's the only evidence in the case, is the one auto-rejected call, is that enough to authenticate the call? Or that perhaps together with the two duo calls?
I would say yes, because especially given the next 2 days, it's from the same person, same phone number, my apologies. And given the observation that the phone is different from social media, that would pass the more likely than not standard. I do agree it would be tougher for the Commonwealth to go to sufficiency if that's the only evidence at trial, but that's not the case here. And unlike McCain, McCain was a case like my friend talked about earlier. It's an Instagram case, and that case was cited to Williams, which is a MySpace case. Those two cases all talk about one thing, which is the defendant had access to the social media, but there's nothing to contextualize who actually authored those messages. In this case, it was just not an auto-rejected call. It was a pattern of contacting the victim with specific text messages to contextualize the April 14, 2020 rejected call.
Well, going back to Justice Sachs' last question and an earlier question, do you agree that cell phones are a little bit different from Instagram accounts or MySpace accounts because they're typically in the possession of the person who makes a call, or so that there might be a basis to authenticate here just based on the record of the victim recognizing the cell phone number that differentiates this case from a MySpace account where different people can get access to the account for different reasons.
I agree there's a difference, especially with social media. You just need to access to that account, and that can be done anywhere in the country or in the world. With cell phones placing calls, I would understand someone might be able to spoof it, but it's more unlikely given the spoofing is not a really common technology, unlike cracking someone's Instagram or MySpace, Facebook accounts. So I do understand it's not a strong distinction, but there is distinction given that having access to a cell phone makes it more likely to place that call. If there are no further questions, the comment will rest on its brief.
All right. Seeing none, thank you both. All right. Our third case is Commonwealth versus a juvenile, 23P887. This is an impounded case, so I'd ask the parties, as you know, not to use any names. Certainly not the name of the juvenile. You want to make a slight? Okay, we're going to make a slight adjustment on the microphone before you get started, so why don't you just... All right. Whenever you're ready.
May it please the court, there are three issues before the court at this point. The fourth issue, I believe the Commonwealth has conceded, which is the sufficiency of evidence of knowledge of the ammunition. So I think the first issue I'd like to start with is the suppression issue. One of the issues that the Commonwealth has raised in its brief, and I would suggest has not raised to the level of appellate argument, is that the affidavit was unsigned. The affidavit is in the record appendix, and it has a typed signature under the /S/, which is pursuant to the Supreme Judicial Court's order allowing the use of electronic signatures. Concededly, the form isn't complete. The counsel could have added in by counsel and added her BBO number, which would be strict compliance with that SJC
So
order.
if we assume the affidavit is from the defendant, then where do we go?
So,
And I guess my question, you can start wherever you want, but my first question is, does everything ultimately depend on whether the so-called plain view seizure was valid?
well, I think
Because no gun was found pursuant to the pat frisk.
that's true, but the pat frisk clearly influences the seizure of it.
Okay, but
because
if the seizure itself is invalid for whatever reason, whether it's because it was tainted by the pat frisk or because the officer wasn't lawfully in position to see in the bag, or because the unlawful character of the gun handle wasn't immediately apparent, everything depends ultimately on the validity of the what I'll call the plain view seizure, without expressing an opinion on whether it actually was plain view.
To some extent, I guess really everything depends on whether the officers had reasonable suspicion or probable cause at the time that they arrived. Because it's at the time that they arrived that the juvenile is separated from that bag, which contributes to the seizure. It's during that pat frisk that the officer is able to have access to that bag. And so I think the difference...
Why do you say that he was separated from the bag? How does...
He was brought down off the porch.
Right, but was he wearing the bag or holding the bag? I mean, there's no
was-
evidence of that, is there?
He was seated next to the bag, and that's the Commonwealth's whole...
Doesn't the 911 caller actually say, I can see there's a bag next to him?
The 911 caller, I believe, said that he was wearing the bag, actually. But
But I mean, don't you have to show that he had a reasonable expectation of privacy in the porch or the bag to get anywhere?
Well, not necessarily. So as to the pat frisk, and this is what, there are slightly different analysis with regard to the suppression derives from the pat frisk or the suppression derives from the so-called plain view. As to the pat frisk, his person is physically seized under any state of the evidence, and that does not involve a reasonable expectation of privacy. His person is seized, he's physically separated from the area of that bag, and so if there's no right to seize his person, that's not dependent on a reasonable expectation of privacy, that's dependent on his right to be free from an unreasonable seizure. With regard to the separate argument, which I think also gives rise to suppression, which is the reasonable expectation of privacy. The affidavit does give rise to that reasonable expectation.
Well, was the affidavit introduced as evidence at the suppression hearing?
So the affidavit was not introduced as evidence during the suppression hearing, but what I would suggest is that the evidence that was introduced at the suppression hearing gave rise to a reasonable inference that he did have a reasonable expectation of privacy. He's on that porch behind a chain link fence with a sign that says
Generally, you
private
don't have
property.
a reasonable expectation of privacy in a common area of a multifamily house, even if you live there. And so where's the evidence that this wasn't that?
So the case law is a little bit conflicting on that. When we look at Commonwealth versus Leslie, the back porch where the gun is found, it is found that there is a reasonable expectation of privacy in that back porch. Here, this takes place on the curtilage of the home, and the police cannot enter the curtilage of the home under Leslie without probable cause and an exception to the warrant requirement, which isn't here.
What's Leslie? I don't see it in your, oh, I'm looking at the wrong brief. Sorry.
But doesn't Leslie say there's an implied license of officers, just like any member of the public, to walk up the front walk and knock on the front door?
Well, I think that's
And therefore, the officer in that case was within his rights to open the gate, walk up the front walk, and engage the people who are on the front porch in conversation. What the officer did not have the implied license to do was to veer off of the walk and go looking for the gun elsewhere on the property. But here the officers were just on the front walk.
Well, I think if Your Honor reads Florida versus Jardines, that conflicts with the idea that a police officer can come onto the porch for any reason at all. If the reason that the police officer has come onto the porch is to knock on the door to ask if somebody is present, that is a permissible law enforcement activity under Florida versus Jardines. But the officer in Florida versus Jardines came onto the porch with a dog for the purpose of looking. Well, this is that same thing. That officer does not go onto that porch for the purposes of knocking on the door. He testifies very clearly that he's on that porch for the purpose of providing assistance with the pat frisk.
Did your predecessor preserve any of this curtilage argument? I didn't see it. In fact, he seemed to say the opposite to the judge.
So if you look at the suppression transcript, and I'm looking at page 36 of day 2, what's argued specifically is essentially they don't get to keep looking and invade the sanctity of your home. Where this porch is, it's a residential porch occupied by one of the residents. It's essentially an outdoor living room, and you've got that bag was not within anybody's reach. So that's page 36 of the suppression transcript. And the Commonwealth never argues that there was no reasonable expectation of privacy. The Commonwealth never defends the motion to suppress on that ground. So it's raised in the affidavit, and it's raised, I would suggest, by the evidence, and it's argued by counsel. So I think when you have the combination of being raised in the affidavit, supported by the evidence, and argued by counsel, that would suggest that it is, in fact, preserved.
Is there a case that says that an affidavit that's not admitted into evidence can be considered for the burden of reasonable expectation of privacy? I'm not aware of one.
I'm not sure whether the affidavit can be considered, but it is considered with regard to whether the juvenile is entitled to an evidentiary hearing. And what I would suggest here is that their evidence, the reasonable inferences from the evidence in this case, do not contradict the inference that he is an invited guest on that porch. They're behind a chain link fence with a private property sign, and they're all sitting on the porch together, and I would suggest that nothing about that suggests that he was not an invited guest.
Is there something that says that being an invited non-overnight guest is enough to give you an expectation of privacy in the place you've been invited into?
There is, Your Honor. Do I have it off the top of my tongue? I do not. I'd be happy to submit that case, but an overnight guest...
overnight for sure, but a non-overnight guest.
I believe that invited guests have a reasonable expectation of privacy, and I'd be happy to supply a citation in a post-argument letter if the court requests.
Sorry, go ahead.
Well, does all of your argument presume that there wasn't reasonable suspicion for the officers to go up the porch because of the waving of the gun and the wearing of the ski masks? It seems to be like the underlying premise of everything you're arguing now.
So with regard to the pat frisk, all that's required is reasonable suspicion. With regard to the entrance onto the curtilage of the property, probable cause is required and exigent circumstances. And with regard to the waving a gun, the Commonwealth cites a couple of cases that are just inept. In this case, the caller reports that the gun is waving around, but there's no indication that anybody has been threatened, that it's been pointed at anybody. And if you look at Commonwealth versus Wade, that's a sufficiency case where the gun is used in a threatening manner towards other people. People are it's specifically the gun was waved at people, and then the defendant ran away from police, ran into the woods, and discarded the gun in a suitcase in the woods. With regard to Commonwealth versus Manna, that was a motion to suppress, but the caller specifically said that the person had pointed the gun at her. The Commonwealth, in its brief, suggests that the gun was shown to somebody. The case is much stronger. Pointed at is different than shown.
Right, but we do know that at least one outside observer was alarmed enough to call the police because of the observing the waving of the gun. So it's not a subjective standard, but is there enough to take from that? Maybe there was some aspect of threatening behavior to this, or.
Well, I would suggest that the waving in and of itself, in the absence of the fact that anybody's threatened, and the caller doesn't suggest that anybody's threatened, he suggests he's concerned about its waving around, but he doesn't say that it was pointed at anybody. He doesn't, and he specifically doesn't say anything about any kind of altercation between the people on the porch. So I don't think the mere waving of the gun, unless it's being used in some threatening manner.
What about the wearing of the ski masks?
So, number one, with regard to the wearing of the ski masks, they're standing on a private porch, and the caller agrees that they're just standing there. And with regard to the cases cited, again, by the Commonwealth, they don't demonstrate, I would suggest, that a wearing of a ski mask is in and of itself criminal behavior or evidence of it. So,
did the officers on the scene know that the juveniles had been reported to be wearing ski masks?
The officers on the scene reported that they did not know that was not in the radio transmission, but to the extent that it's in the call itself, Rousseau, cited by the Commonwealth, again, is not a suppression case. That involves the sufficiency of the evidence in a case. In Ruiz, the defendant removed a mask near the scene of a robbery where a mask had been involved. In Letkowski, cited by the Commonwealth, the attacker had worn a mask, and they found that it was reasonable to assume that the defendant was the person who had been wearing the mask during the attack. And finally, in Woods, which the Commonwealth cites, that's not even a suppression case either. That it just cites the fact that the defendant was wearing a mask when he shot somebody. So none of the cases that the Commonwealth has cited support the proposition that the mere wearing of masks is reasonable suspicion. And here, we're not talking about approaching a bank or a store or a passerby. They're all just standing on a porch. So I think the combination of, number one, the officers weren't informed that there were any masks goes to the issue of safety, but also...
Counselor, before you run out of time, I do have a question about the Guardado issue.
Yes.
Guardado 1 tells us that if the trial happened before Bruin came out, the defendant didn't have an adequate opportunity to raise this issue, but this trial was after Bruin came out. So how is it, maybe it's not preserved. What's your argument on preservation?
Well, my understanding of Guardado is that after Bruin and before Guardado, the issue is preserved. Because, again, Bruin doesn't say anything specifically about the burden of proof. Bruin doesn't alter the...
Sounds like you think Guardado was wrongly decided.
I'm not suggesting Guardado was wrongly decided. What I'm suggesting is that Guardado overruled a directly on point precedent in Massachusetts. Bruin didn't explicitly overrule that precedent. Bruin was a case where the SJC determined that the U.S. Supreme Court precedent required them to reach a different result, but a trial court would have remained bound by Powell and the previous cases. And if I see that I'm running out of time, but just in answer to your question, if I may point out, the Commonwealth suggests that the defendant didn't challenge this evidence, but I would suggest that in comparison with some of the cases the Commonwealth cites, the evidence was that the juvenile was asked whether he was being detained. That the juvenile was being detained, and this is trial transcript 1 at page 68. We learned his age and asked him if he had a license to carry. He did not have a license to carry, and due to his age, he wouldn't be able to possess an LTC. But they don't say that he answered that question, and they don't say the source of the information about his age. So although there was some evidence, the basis of that evidence is unclear. It's unclear whether they looked it up, and I would suggest, given the state of the law, that there was going to be an instruction that the lack of a license wasn't an element of the offense. Counsel had no reason to challenge that particular evidence. It wasn't argued, and there weren't multiple references in the testimony, which happens in many of the cases cited by the Commonwealth. And if there are no further questions, I would rest on the brief.
All right, thank you. We'll hear from the Commonwealth. Mr. Hanson.
Thank you, Your Honors. Arne Hansen for the Commonwealth for the Plymouth County DA's office. With respect to the first issue, the stop in this case was good. It was supported by a reasonable suspicion of criminal activity. The Commonwealth's argument is not that one element in this case, whether it was the waving the gun, the ski mask, or any of the other issues, the high crime area, the time of night.
It's the totality.
Correct.
All right. With respect to the masks, the judge didn't make any finding about the masks. The officers testified, or maybe the one officer who was asked said she wasn't aware of a report of masks. And the recording in the 911 call and the dispatch calls that resulted from it show that the information about the mask was not communicated to the officers in the field. So therefore, can we consider it?
That's a fair assessment, and I would say even without the masks, this case survives the motion to suppress.
So can we consider it? can we consider the masks?
If it was not in any of the communications, and I understand that it was also not developed in the record at the motion to suppress, so it's certainly fair to say that the masks might be out. But the case survives anyway. I think Commonwealth v. Edwards is very much on point. That's a 2018 SJC case there where we have a 911 caller observe someone at night in a high crime area, similar to the area in the question here, report that a person has been handling a firearm, is carrying it in his hand, puts it back in his car, takes it back out, and then just remains in place seated in his car there. That gave rise to a reasonable suspicion that the firearm was being used for unlawful purposes. The other consideration that they had was that there had been several shootings and homicides in that location as well, which is similar to the case at Barr, where there had been 2 firearms recovered on that street prior to this stop.
So even if there's reasonable suspicion to support the pat frisk, that doesn't get you to the gun. You still need to show that what you're calling the plain view seizure of the gun was valid. Is that correct?
Yes, so that goes to the second argument, which I can move on to. The crux.
And I'm particularly interested in why the unlawful character of the gun was immediately apparent.
I would cite to the Rodriguez case, Your Honor, with respect to that one.
Which case?
The Rodriguez case. It's an unpublished case that I cited in my brief.
Yeah, in Rodriguez, there was no discussion whatsoever of what evidence supported the unlawful character of whatever was spotted there. I can't remember if it was a gun or drugs. So what do we take from that case? Not only that it's an unpublished case, but how does it support the unlawful character of the gun being immediately apparent to the officers here?
Oh, I would go back to the argument as to how the firearm was being used. In this case, I cited waving a gun is not indicative of, and that this was communicated to the officers via the radio call. Waving a gun is not indicative of responsible firearms use, which would be more indicative of someone who doesn't have a license to carry.
But it seems your immediately incriminating is dependent on you being right that there's reasonable suspicion to think the gun's illegal in the first place.
Correct.
Isn't it? All right. So they're interlinked.
Yes, so the way that the firearm was being used, which warranted the call, would also support the idea that the firearm was not legally owned.
So is it enough to support a plain view seizure that there's reasonable suspicion about the gun having been or being or about to be used in a crime, or does the unlawful character of the gun have to be immediately apparent, which arguably is a higher standard?
I would just argue that the facts and circumstances of this case suggested that the firearm was being used illegally. I mean, the way that it was being carried as well. One of the cases that I cited states that carrying a firearm in a holster would be indicative of proper use of a firearm. This one was just in a bag. It was sticking out of a bag. It didn't fit inside the bag.
But there's nothing unlawful about carrying a gun in a bag, is there?
No, there is not. I'm not sure I have anything else that can address the court's question. Now, with respect to the reasonable expectation of privacy, 2 SJC cases recently held, Jesus in 2022 as well as Souza in 2023, held that individuals don't have a reasonable expectation of privacy in the common areas of a multifamily dwelling, which is the exact circumstances that the defendant finds himself here.
Okay, sorry, could you just slow down a tiny bit and try to speak into the mic?
Sorry.
Yeah, thank you.
So in the Jesus as well as Souza, the SJC held that individuals do not have a reasonable expectation of privacy in the public areas of a multifamily dwelling. That's exactly the case here, where the defendant is standing outside of an apartment building or multifamily dwelling. The officer approaches. Now, with respect to the defendant's affidavit, I should say the burden is on the defendant to show that he did have a reasonable expectation of privacy. What we have here is an affidavit that is signed by defense counsel, which states that he was an invited guest at 19 Wilmington Street, and that's all we have here. That record was not developed at all by the defendant at the motion to suppress hearing, and it would have been his burden at that time to do so. Right now, we have more questions than answers. We don't know who invited him there, how long he was there, why he was there, who from that group of 6 people lived at that building that did have a lawful right of access to that building. For all we know, all 6 individuals were trespassing at that location. And we don't have the answers to these questions because the defendant never developed that record. So for all intents and purposes, they could have been trespassing, but it was just a question that was never addressed by the defendant.
Even if you're trespassing, if you have a bag that's in your possession, do you have a reasonable expectation of privacy in that bag?
So Officer Bunker testified that the bag was laying on the porch,
Right.
which was in the common area.
After the juvenile was instructed to come down from the porch to be pat frisked.
The testimony from the 2 officers appears to be somewhat incongruent in that sense because the Officer O'Donnell seems to testify that she immediately approaches the defendant, or the juvenile, and searches him, whereas Detective Bunker testifies that the defendant was still seated on the porch next to the bag and then went down to get pat frisked. So it appears that he observed that before the initial pat frisk, but then Officer O'Donnell testified that the other officers came in after the fact. So the record is somewhat unclear as to that.
And we take into account in determining whether he had a reasonable expectation of privacy in the bag, that the bag had his, a debit card with his name on it, and that he spontaneously said at the police station when the bag was searched and some keys were brought out, oh, those are my work keys. Does those pieces of information support that he had a reasonable expectation of privacy?
I would argue that where the bag was left the bag was just left on the porch and nobody appeared to claim ownership to it. The firearm was sticking out.
Did the judge make a finding about that?
Not that I recall. It's possible, but I don't remember off the top of my head.
That she says, while on the porch and while Officer O'Donnell was pat frisking the juvenile, Officer Bunker noticed a small bag on the porch. The bag was located at the far end of the porch where the juvenile had been seated. So that's what we know from her findings about the bag.
Right. With respect to plain view, Commonwealth needs to show that the officer had a lawful right of access to the front porch, that he was in a lawful position from where he was able to view that bag, that the item's incriminating character was immediately apparent, and that the officer came across it inadvertently.
How was the incriminating character immediately apparent?
It's a firearm.
Yeah, but not all firearms are incriminating. I'm trying to understand sort of your logic. Because the juvenile was waving around another gun, and that there was a nexus to this firearm and that one. I'm just trying to understand your reasoning.
Right. So firearms within themselves aren't illegal. Yeah. It's the possession by certain individuals that makes it legal or illegal. So in order to possess a firearm or carry a firearm legally, you need to have a license to carry. Right. Now, I think it would be fair for officers to secure a dangerous weapon like a firearm first prior to addressing the question of do you have a license to carry. I think that those can be done simultaneously, but I think it's important for them to, for safety reasons, to secure that firearm first before then asking the second question. Now, if the defendant had produced an LTC, they certainly could have given the firearm back in a safe manner.
That seems to be a different argument, though, right? I mean, I wouldn't disagree that officers should secure firearms in a situation like this, but you said that the incriminating nature of the firearm was immediately apparent, and I just don't quite understand your argument there.
Yeah, I guess it relies on retrospect to find out after the fact that he's not supposed to carry the firearm, but I would suggest that just based on its nature, the fact that it's a dangerous weapon, that officers should be able to make that determination on scene.
But that's also dependent on them having reasonable suspicion for this interaction in the first place, right?
Correct.
Like maybe they can secure a gun while they're doing a legitimate reasonable suspicion investigation, but not if they don't have that, right?
Correct. So my argument would be that everything built off of how that firearm was being used prior to police arriving, and then how that firearm was stored, and then the individuals, how those individuals interacted with the officers on the porch.
If the pat frisk was invalid, was Officer Bunker getting into position to cover the pat frisk also invalid?
No, I would suggest that those are sufficiently attenuated. With respect to attenuation,
Well, wait a minute. The Officer O'Donnell started to conduct the pat frisk. Officer Bunker got into position so he could cover the pat frisk. That's what he testified.
yes.
How was that independent of the pat frisk, him being in that position?
So with respect to attenuation, there's temporal attenuation, intervening circumstances, and how integral to the search, the discovery of the contraband was. Here, the pat frisk didn't result in the discovery of any of the weapons. The firearm was not discovered as a result of the pat frisk, and the knife, despite the fact that the first officer pat frisked the defendant, wasn't found on the defendant's person. It was only found after a search incident to arrest by a different detective who then took the defendant into custody. So the question here is, did the evidence come from the exploitation of the pat frisk?
Well, so if there's no reasonable suspicion to conduct a pat frisk, what's the justification for an officer covering the pat frisk?
I'm arguing that there is a reasonable suspicion.
I get that, and if you succeed on that, we won't have to worry about the taint of the illegal pat frisk. But if we don't go there, I don't see how the cover officer right to be there isn't dependent on the pat frisk being.
The cover officer's standing in the front yard, and he's predominantly watching the other 5 individuals that aren't being searched at that time. So his actions are more to ensure the safety of the other officers when they're focused on the juvenile in question, to make sure that those officers don't get.
So if they weren't doing the pat frisk, then there would have been no need for this officer to keep his eye on the 5 others.
I would disagree with that, where there were 6.
And to get into position to do it, and from which position he saw the gun in the bag.
I think Officer Bunker was covering the scene. He was standing off to the side of the porch in a position where he could view everyone at the same time, to make sure that if anything dangerous had transpired, he would have been able to react to that. I think independent of whether or not the pat frisk was going to happen, he was going to stand off to the side where he was.
Was there any testimony on that? Was this attenuation theory developed by the Commonwealth at the suppression hearing?
No, it was not.
So
with respect to his testimony, he did state that his objective by standing there was to make sure that none of the other individuals did anything while the first 2 officers were interacting with the juvenile, and the purpose of him doing that was just to keep an eye on everyone. And then he inadvertently saw the firearm sticking out of the bag as well. He did state that his objective was not necessarily to search, because he was worried about the other 5 individuals on the porch. But in doing so, he saw the bag with the gun sticking out of it. So in that sense, the testimony was developed, but attenuation wasn't specifically argued by the ADA at the lower court.
I should have asked your friend this, but there's a picture of this porch that was Exhibit 1, and I don't remember whether that was the Commonwealth or the defendant's exhibit. Do either of you have it? Able to get it to us?
I don't have the exhibits with me, but
Not with you, but could you?
Yeah, I can go to the juvenile court, and as I did with the 911 call, make copies specifically of the juvenile court's exhibits.
Do I recall seeing that it was a Google Maps Street View screenshot of the porch? Did I see that?
It's my memory, but I haven't looked at that exhibit specifically to confirm.
Well, I mean, I suppose if you and counsel can stipulate that whatever you're submitting to us is an accurate representation of, well, I guess we'd really like to see the exhibit.
I can get I can get copies of I work across the street from the juvenile court. I can get copies tomorrow for the court.
That'd be great.
Thank you.
All right, thank you. Thank you for your arguments. We'll take our morning break now, a little earlier than anticipated, and we will be back out in 15 minutes.
All rise, please.
So that's 1 and 2. All right. Thanks a lot, Tom. Whoa. All right, now can you hear me? I think this is a little loud.
Well, it depends how close you're going to stand to it. Testing 1, 2.
Testing 1, 2.
They're just testing the mic to make sure it's okay.
Testing 1, 2.
You're not very close to it.
Testing 1, 2.
Yes. All right, you can set it, sir.
Right, we are back for our final three cases, and these are all civil cases. Our fourth case on those today is number 23P1075, TRAN versus Campbell and others. And Mr. Tran, you can argue from the seated position. I think a microphone's been hooked up for that purpose. Fine if you take notes on your laptop during the argument, and if there are questions that you need us to repeat, then just ask us and we'll do that. Okay. So whenever you're ready, you can begin.
Members of the panel, my name is TRAN, the appellant plaintiff arguing on behalf of myself against my former employer, Liberty Mutual, and former supervisor, Terry Campbell. Today, I want to focus on correcting injustices from the trial court's errors of laws when determining whether self-help discovery was protected, when instructing the jury on retaliation, and when allowing prejudicial evidence to prove character and lay opinions on ultimate issues. Your Honors, I realize you hear many cases throughout this court year. This one is distinctive because it concerns the protection of fundamental rights and equal justice. There won't be time to go over everything from my pre-statement, but if you have a question related to any issue, don't hesitate to interject. I want to mainly direct my oral argument to the matters of self-help discovery, which are relatively new issues and which contribute to the long arc of history to remediate matters of employment injustice and balance. The U.S. legal system has a proud history of fighting discrimination, dating back to the first Civil Rights Bill in 1862. And indeed, the country has gone a long way towards eradicating the practice, one step at a time. The early laws guaranteed citizens equal access to public and commercial establishments, followed by ensuring voting rights for all, then progressed to employment discrimination, and more recently expanded whistleblower protections. Does it mean that workplace discrimination has disappeared? No. Although the purpose of these laws is to reduce their incidence, discrimination still manifests itself, but in different forms. As you can imagine, prejudicial behavior has become more insidious over time. Employers no longer openly discriminate by what they say, but now they just treat certain employers worse based on their protected class as opposed to objective criteria. In other words, engage in disparate treatment. These type of biases, even if they are only felt implicitly, are akin to snakes hiding in the grass and are still illegal but much harder to prove. In Massachusetts, the state's progressive anti-discrimination laws were 2 decades ahead of the nation when, in 1946, they passed General Law Chapter 151B. Over the years, the state law incorporated new acts and amendments with its vision of fully weeding out workplace injustices against protected groups. The Massachusetts judiciary also understood that employment discrimination was a complex topic, and the law must be interpreted with its broad remedial purposes in mind, consistent with intentions of the original framers. One example is the court opinion in Verdrager versus Mintz, which articulated the legal framework to determine whether self-help discovery is protected activity. The SJC ruled that in, quote, close cases, unquote, the courts must accept these broader remedial considerations to tip the balance. The reason is that there's greater risk of injustice to deny employee protection for oppositional activity under Chapter 151B, Section 4, if the totality of circumstances were toss-up. This is the essence of the seventh and final factor of the Verdrager balancing test for reasonableness. Other appellate opinions also recognize the power dynamics between employer and employee are not equal.
Mr. Tran, I'm going to ask you just to try to slow down a little bit, just so we make sure we understand your argument.
Sure.
Thank you.
Other opinions have recognized the power dynamics between employer and employee are not equal, and consequently the courts sanctioned informal discovery many years before Verdrager. For example, in 2002, in Messing versus Harvard, the SJC authorized informal interviews of employees without involvement of corporate counsel, noting such discovery provide, quote, more meaningful disclosure of the truth, unquote. And in the case of Quinlan versus Curtis Wright on self-help discovery in New Jersey, the courts similarly characterized the anti-bias laws as, quote, remedial legislation that was intended to be given a broad and liberal interpretation, unquote, with an essential purpose for, quote, eradication of the cancer of discrimination.
So, may I ask you a question?
Yes.
What exactly did the judge do wrong in instructing the jury on self-help discovery?
There were five things I argued in my brief. One was the fact that she instructed not just on a particular document. So the laws state that the smallest unit to determine self-help is a document. So each document needs to be measured by itself. And what she was doing was she was parsing the document into these small pieces. So that was one thing.
Did you ask her, or did trial counsel ask her to make a ruling on each individual document as a whole and either instruct the jury either that it could be considered as fair game for self-help discovery or that it couldn't?
There was objection, yes. There was a objection to the quote-unquote parsing of the documents. It was rejected to a few times during the course. So there was, so the attorneys did do that, yes.
So the attorney trial counsel asked the judge to make determinations as to particular, I suppose it was emails that you forwarded to yourself.
Yes.
Whether that email as a whole was permissible self-help discovery or not.
Yeah, essentially the judge says there are certain portions of certain emails which I've deemed not to be protected. And
attachments with spreadsheets and data about trades and things like that.
Sure. And my counsel said, object that the purpose of the laws is not to look at each document into its little parts and dissect them, because that's not what the Rodrigo rules and the other opinions say. That you really need to look at it as an entire document. That and further, there is no confidential information that rises to the level that it would need to be not taken or redacted, and that was the discussion points that were given to the judge. Employers like Liberty, when defending Chapter 151B claims, will argue against the fairness of such rules and meanings. They say that tipping the scales in favor of the employee means the courts cannot be impartial, but their contention misses the mark. The objective of these broad remedial measures is to correct an injustice. Here are two parties, the employer versus the employee, who clearly aren't comparable in their resources or their access to documents. The just solution is to get them a little closer to equal footing so that the huge advantages enjoyed by one side are not so imbalanced. Sadly, Liberty's defenses and several of the trial court's rulings diverge from the spirit of Chapter 151B's broad remedial intentions, similar to the branches of a tree swaying in opposite directions. Liberty's primary argument against protections for self-help discovery is that the documents didn't evidence discrimination. Why is this argument not only flawed, but also disingenuous? First, keep in mind that the company's counsel are employment experts, so of course they know that direct proof, such as the boss openly admitting that they discriminate, is highly unusual in today's workplace. Therefore, indirect proof of disparate treatment, such as comparator evidence or information that supports a rebuttal of the employer's assertion of poor performance, actually carries enhanced importance. But the other side knows all this. In the 2005 case of Sullivan versus Liberty Mutual, from the company's prior litigation, the SJC ruled that, quote, the employer's state of mind is elusive and rarely is established by other than circumstantial evidence, and direct evidence of those elements, discriminatory animus and causation, rarely exist. A corollary to Liberty's argument is that the protections in Rodrigo don't apply to the self-help documents here because they aren't discoverable. But even if we assume some work documents aren't directly relevant, Liberty's reasoning still lacks credibility. The damages in this case are very high, estimated at $15 million, according to testimony of the economic expert witness. You can verify this in Record Appendix 2 on page 1419. Due to the large amount at stake, the motion judges consistently allowed broad and in-depth discovery of electronic documents from both parties. That is why the record appendices here are over 7,500 pages. In fact, Liberty, in response to discovery, had to produce every page of every email and attachment between myself and my former supervisor during the period in controversy, without a single redaction. During discovery, Liberty went so far as to threaten a motion to search all my laptops, phones, USB drives, and any other storage devices in my possession in the past 7 years. Your Honors, Liberty is fully aware that all content in the self-help documents is discoverable. Their claim otherwise is as flimsy as a kite in a raging storm, lacking sincerity and substance.
Can I ask you to, one of the points that Liberty made and makes now is that you access some documents that were completely unrelated to your discrimination retaliation claims. And they point to slides prepared for the investment board, an email containing a dashboard and discussing strategic changes to the company's investment portfolio, trade confirmation spreadsheets. Are each of those items relevant to your claims?
Yes.
Okay.
Yes, I mean, this is because...
Could you just walk me through that? Why, and if so, why wasn't the jury allowed to make a judgment as to whether or not they believe these documents directly bore on your claims or not?
So, first of all, I think the Verjerger case, I think footnote 35 says that it's the judge that ultimately makes decision as to the final determination as to whether or not it's protected or not.
You don't think the jury should have been allowed to assess the facts and decide whether or not the documents you accessed were relevant or not? It should have been a judge-made decision?
Yeah, the judge, the jury only has the ability to determine quote-unquote subsidiary facts. That's what the case, Verjerger case, footnote 35 says. And a subsidiary fact is, for example, whether they were fired, the employee was fired, if they were motivated by, let's say, the taking of the document or the using of the document at a deposition. That's one of the examples. So whether or not there was a pretextual motivation, that's the jury's input into it, but not whether, which documents are protected.
Well, so can you just get the trade confirmation spreadsheets? How are those relevant to your claims?
Yeah. So the trade you're talking about the post-trade spreadsheets.
Yes.
So those evidence that was a disagreement between myself and my supervisor. And keep in mind that at that point in time, the issue was performance and whether or not I was meeting performance expectations, and so that was a very relevant issue in terms of if not direct evidence, indirect evidence. Any sort of communications between myself and Campbell and any information, any spreadsheets that are attached to it are relevant, and these are not. And keep in mind, these are not highly confidential.
Yeah,
documents.
but I'm just focusing on relevance. So what about the strategic changes to the company's investment portfolio?
Yes.
How are those relevant?
So those are also related to work that I had done, and those were the subject of criticisms. Each one of them were either the subject of criticisms or harassment or somewhat related to performance of myself. And so I needed those documents in order to have the complete picture of what was happening at that point in time.
And so your argument under Verjerger is that it wasn't sufficient for the judge to instruct the jury, well, you decide which information directly bears on his claims and which does not, that the judge should have made a ruling as to each of these documents and instructed the jury as to relevance?
Yeah, so that's one of the, I think one of the many points that I make in terms of the errors from the judge standpoint.
Didn't your proposed jury instructions ask the jury to determine for themselves whether your self-help discovery was reasonable?
Yes. They said they ultimately, she gave the instructions to the jury to ultimately make the determination.
But isn't that what your lawyer asked for in your proposed jury instructions?
Our proposed jury instructions was to examine the seven factors in conjunction with this case, but yes, he may have done that. Okay. May have done that, but I'll leave it at that. Employers, how do liberties defenses tie back to my early remarks? Well, the intent of the legislator and reading by the judiciary is that the employee enjoys the benefit of the doubt to pursue good faith claims. The authorities also recognize that with the passage of laws prohibiting discrimination, employers wouldn't be so foolish as to openly admit their animus of a protected class. However, that doesn't mean that they aren't motivated to act under animus, even if indirectly or by pretext. Employers like Liberty will also argue that the court's sanctioning of self-help discovery will, quote, open the floodgates by granting protected status to such conduct, unquote.
Mr. Tran, I just want to caution you that you've got 30 seconds left, so however you want to wrap up or whatever else you want to address.
A concern from Quinlan and alluded to in Verdreger when warning employees that their acts may not be protected, and to placate employers who worry about such a flood. My response is to ask, where's the flood? In the last 8 years since Verdreger, this is the first known jury trial on this topic, and this will be the first appellate opinion. And finally, I just want to say that we're just talking about 11 emails at issue here with the lowest level of confidentiality. There was no consistent enforcement, nor did I receive any prior email before they fired me. They testified that no other employee had been fired for this.
All right. Seeing no further questions, thank you for your argument. And we'll hear from the defendants once the microphones are adjusted. Mr. Persky.
Thank you. May it please the court. Jonathan Persky for the defendants, Liberty Mutual, and Terry Campbell. The SJC's decision in Verdreger opened the door slightly for self-help discovery. It did not break the door down. It is not open season on the company's documents. The case requires balance. Balance between the employer's legitimate interest in maintaining confidentiality and the employee's legitimate interest in pursuing a legitimate claim of discrimination. All of the information at issue in this case, all of it, was protected under a clear, unambiguous company policy. Do not send company documents to your personal email address. Verdreger says that if you take documents that aren't relevant, that is not self-help discovery. It's a threshold rule.
Verdreger say you can, how does it define a document, or does it? So where you have an email, a string of emails, and some documents were attached to the very first email, is the whole package protected, or does Verdreger support any inquiry into, well, so there were some easily separable portions like the attachments that could have been deleted and perhaps should have been?
Verdreger supports the position that you have to take information from each document relevant to your claim in order to preserve a claim of self-help discovery. The entire document is not protected. I would refer the court to footnote 38 in Verdreger, where they discuss a Word document that was taken by the plaintiff in that case that contained transcriptions of all of voicemails left for a Mintz-Levin partner. And the court said in that case, there may be a spectrum of whether or not actions are reasonable. On one end of the spectrum, you have the memos that were created by Mintz-Levin that bore directly on the issue of gender discrimination. On the other side of the spectrum, you have the voicemail memos with the exception of a single message that was relevant. So the SJC in that footnote in Verdreger clearly stated that the plaintiff has an affirmative duty to take only what is necessary. And that goes right to the principle of balance.
How do you do that if you're forwarding email to yourself? I mean, how do you redact the email? You send the email to your Gmail account and then you go through and make a redactions on the spot?
Well, you certainly could do that, but there's an element of reasonableness involved. So in this case, we have images that were embedded, and that's the board slides document, Exhibit 60. And then the most egregious case, I think, is the spreadsheets, which is Exhibit 54. Because those were attached, these email attachments to the email that Mr. Tran forwarded to himself, and inside each of those attachments are spreadsheets. The spreadsheets are not relevant.
Are they relevant to show that the criticisms that his supervisor leveled against him were unfounded somehow? I mean, I understand that's the argument he's making.
No.
Not only has to claim they're unfounded, but he needs to be able to prove it to show that her actual motive was discriminatory.
He doesn't need to prove it because on cross-examination, I established there was actually no dispute in the facts that the spreadsheets were intended to show. And in fact, there's a very interesting admission in the reply brief on page 8.
I'm sorry, I didn't catch that first point.
I'm sorry.
You established on cross-examination what?
We established on cross-examination that there was no dispute in the facts that could have been resolved by recourse to the spreadsheets. So there was a summary. So the way that Exhibit 54 proceeded.
Could he have known that at the time, that there was no dispute? When he forwarded the email to himself, did he know what Ms. Campbell was going to dispute or, and later dispute or acknowledge?
There was no dispute raised at all with that issue, because what had happened in Exhibit 54 was that there was a goals document with an update on Mr. Tran's objectives, and Ms. Campbell responded to that goals document with constructive feedback on the commissions owed to various brokers. And the response to that was, I looked at your comments, and here is a set of spreadsheets that shows 26 basis points for post-trade execution and 32 basis points for pre-trade execution. We established in a cross-examination that those numbers, 26 and 32, that were derived from Mr. Tran's reliance on the spreadsheets were never in dispute. So this is not actually legitimate.
Again, when he emails it to himself, how is he going to know whether those numbers will eventually be in dispute?
So, yeah, Ms. Campbell had not actually disputed those numbers right at the time, and you're right, he doesn't know at that time when he forwards the email to himself whether or not there's actually a dispute. I think Verdrager gives him an affirmative obligation to determine whether there is a dispute before he sends these highly confidential documents to his Gmail account. This is exactly the balance that Verdrager demands. He needs to establish that the documents are relevant rather than presume that they're relevant in the first instance. And in fact, in his reply brief, Mr. Tran says that the reason that he forwarded the spreadsheets, the reason that he thinks the spreadsheets are relevant, is because Tran needed them to confirm performance numbers from the body of the email. So he doesn't actually need the documents. He wants to substantiate that the information in the email to Terry Campbell is backed up by the recourse to the documents.
I mean, and maybe the reason why it's not disputed at trial is because he had the evidence to prove that he was right and Terry Campbell's criticisms were wrong because he emailed them to himself.
If you look at Exhibit 54, Terry Campbell's criticisms don't actually go to those documents or any of the information in those documents. It's simply not relevant. And even the whole issue of performance, and this was the court below.
The issue was why he was seemingly favoring a particular broker and not spreading the trades around among various brokers, and he was trying to establish, hey, this broker's doing a really good job for us.
That was the concern.
So isn't that a relevant rebuttal to her point?
The information in the email that he sent to her explaining that issue very likely is a relevant rebuttal to that point. The issue is the spreadsheets, the highly confidential documents that were attached to them that were not necessary in order to make the point that Mr. Tran was making to a supervisor. It simply has no relevance, or to the extent that it is relevant, the 7-factor Verdrager test argues against including that in protected self-help discovery.
So was the jury supposed to sort out whether each document was protected self-help discovery or not, and therefore potentially fair game for discipline, or was the judge supposed to make a ruling on each document?
What the court did was outline the types of documents that were covered under Verdrager and the types of documents that were not covered. It was a pretty elegant solution in my view.
And leave it to the jury, but under Verdrager, should the judge have decided it herself?
No, so as Mr. Tran said, footnote 35 in Verdrager allows the jury to find subsidiary facts to the issue of whether or not protected activity has been engaged in. Whether the protected activity, whether a certain document constitutes protected activity is a question of law, and the judge found as a matter of law that documents concerning performance or concerning communications with a supervisor were in fact protected under Verdrager, giving him the benefit of the doubt on all 7 factors. And the judge decided as a matter of law that documents that had little, if any, bearing on his performance and were highly confidential and sensitive were not protected under Verdrager.
Right, but the judge still instructed the jury, she instructs us on that distinction, but had the jury apply it. And I guess the question is, do you think that's the right approach, that the judge lays out, sort of defines the 2 different categories, but has the jury actually make these kind of relevancy determinations in their deliberations? Is that what Verdrager anticipates?
Absolutely. I think footnote 35 makes it clear that the jury is able to make that subsidiary determination with the guidance of the court through her jury instructions, which are subject to the abuse of discretion standard.
Okay. And her formulation was Mr. Tran could forward to himself information directly bearing on his performance, but information that is confidential or sensitive and has little, if any, bearing on his performance does not constitute protective activity.
Right.
Is that, you think that's the right standard under Verdrager?
That's exactly a correct statement of law.
Okay.
Under Verdrager.
Mr. Tran takes a broader sense of relevancy, and I think he relies on kind of the retaliation substantive standard and sort of, information that he believes is relevant to his claims. Yeah. And your argument is no, that goes too far.
No, and I understand Mr. Tran made an argument based on NISWAND, the Sixth Circuit case that's cited in Verdrager, but Verdrager applies an objective standard to relevance, which is recourse to Rule of Civil Procedure 26. If the document is discoverable, that's the threshold inquiry on Verdrager. If that is discoverable, then you go to the 7-factor Verdrager test. If the document is not discoverable, it falls out of the test and it's not protected activity.
It's still a little strange to have a jury kind of making all these relevancy determinations. Is there another context of law where the jury is sort of ruling on relevance issues? I'm trying to think of it.
It's unusual, right? Because Rule 26 is kind of built into this legal framework, and it's not actually a discovery rule, but it's an application of a discovery rule. I think it's appropriate here under the subsidiary findings language in Verdrager, because there was competing evidence, and Mr. Tran introduced evidence on why he thought the documents were relevant. We introduced evidence that the documents were not relevant and are highly confidential and sensitive, and the jury appropriately made the distinction, was able to decide which side had more credibility in determining which documents fell within the scope of protected activity as the judge outlined it, and which did not.
But the jury did more than determine subsidiary facts here as note 35.
Sorry?
They make subsidiary determinations. The jury did more than that, didn't they?
I don't think so, based on my reading of footnote 35. I don't think the jury did more than they were entitled to do under the framework expressed by the judge.
They must have decided whether those emails were a permissible basis for self-help discovery, or permissible subject of self-help discovery.
No, they decided whether or not the documents were directly related to performance or communications with the supervisor, or on the other hand, whether the documents had little, if any, bearing on performance and were confidential or sensitive. The judge set out the framework in her jury instructions to make the jury decide which one of those two categories.
Isn't there some room between those two standards that's not covered by either?
Sorry, room between?
Between the two standards of directly relevant to performance and whatever the other one was, only indirectly related.
I think the implication of the instructions.
And highly confidential and significant to the company. I mean, it seems like there are some documents that might not fall within either of those two categories. And what is the jury supposed to do with those if they think so?
Well, I think the jury instructions set out a spectrum in which the jury can evaluate, is it more on this side or is it more on the other side? And I think that's an appropriate determination to make.
Why wasn't the judge supposed to do the Verdrager balancing test herself and determine whether each email was protected or not, and then ask the jury, was he fired because of these emails or the ones that aren't protected? Why wasn't that what Verdrager requires?
Well, Verdrager doesn't state that you have to do that on a document-by-document basis. The Verdrager states that you have to decide on a case-by-case basis with respect to the information taken, whether or not that is a reasonable, whether or not it is self-help discovery to begin with, whether or not the document is discoverable, and then after that, whether there's a reasonable basis to take the document using the 7-factor test if discoverability is determined.
Sure, but wouldn't the instruction be something like, okay, this email here, the email was protected, but the attachment wasn't. Now, go decide whether he was fired because of the email or because of the attachment. Mm-hmm. Isn't that what the judge should have done?
The judge could have done that.
I mean, that's the correct, legal analysis.
The judge certainly could have done that. I don't think there's any error, and certainly no harmless error in the way she approached her formulation of the jury instructions in this case. Unless the panel has any further questions.
I do have a question. If you have something on Verdrager, this is not on. So, I've read quite a bit of this transcript, but I certainly have not read it all. And I found the written objections to the Samuel Bong, I don't know if I'm pronouncing that right, deposition, but I couldn't find where the judge ruled on them or where it was discussed. You give me a section to go.
I don't know if I can give you an exact record site. It is in our brief, but
even the region would be nice.
Sure. On page on the Bong issue, it's the written portion of the transcript that the judge ruled on, I believe, is Record Appendix 2, page 4293, and it's reproduced in the plaintiff's addendum at page 86.
Thank you.
All right. Seeing no further questions, we thank you both for your arguments.
Thank you.
So we're finished. Take the case under advisement. And the next case is 23P 1341, James Larson versus Keith Devine and another. Mr. Moynihan, whenever you're ready.
Good morning, Your Honors. James Moynihan for Keith Devine as the trustee of the Mary V. Larson Irrevocable Trust. The reason for this appeal is that the trial court erred in interpreting the trust because it did not read it as a whole trust, but rather it took one clause in isolation to the detriment of other clauses in the trust. And because of this error, the court found that there was a breach of fiduciary duty for failure to pay $50,000 to Mr. Larson when it was either impossible to do so or doing so by sale would be against the direct terms of the trust. The reasons it was impossible is that there was no cash in this trust that was known to the plaintiff and all parties at the outset. Secondly, it was impossible to get a loan on the property. So my client came into this case trying to resolve it.
What's the evidence that it was impossible to get a loan on the property? I know it was said at various hearings. Is there actually evidence establishing that in the record?
The evidence is the affidavit of Keith Devine.
When was that filed?
And that was, he filed several affidavits.
Was it after the summary judgment ruling?
Yes, it was after the summary judgment ruling because at that point there were his brother was also a co-trustee, so there wasn't a unanimous decision between them. You know, he didn't have the ability to act independently to try and go get a loan. So what happened is after summary judgment.
Wait. Keith and Mark have to agree not to sell the property, correct? So
that is correct.
Keith on his own can decide that the property should be sold. Keith, now the remaining trustee, he has the sole power to say this property should be sold.
So
is that correct? It's
no,
not,
I disagree with that, Your Honor.
Keith could not, the section, I think 509 says, Keith and Mark have to agree not to sell the property. 509 says, sell the property as soon as practicable. But if Keith and Mark agree not to sell it, then that's okay. But so it's in Keith's power to sell at any time. Isn't that right?
So I disagree with that because there's a distinction between Keith and Mark as trustees and Keith and Mark as beneficiaries. The clause you're referencing, the unanimous agreement of James, Mark, and Keith, that's their role as a beneficiary. And the reason why that is as beneficiaries is if you look at that language, it says, unless otherwise unanimously agreed by James Mark Devine and Keith Devine, if then living, and if either or both of them is then deceased, by the living descendants of James Mark Devine and Keith Devine. So this ability to agree to continue to hold the property passes on to their descendants. And so that is not their role as trustee, that is their role as a beneficiary under the trust.
But whether trustee or beneficiary, what 509 says is that if they both agree that it shall not be sold, it shall not be sold. It doesn't say they come to own the property, does it? I don't see any distribution language in 5.09.
So it doesn't, but I think that language is expansive. But I think the intent was that this property remain in this irrevocable trust and they can live there. And the reason...
Well,
You think that...
in 5.09 on page 99 of the record, notwithstanding any of the foregoing, no joint tenancy or tenancy in common shall exist as between the beneficiaries of the trust and the real property owned by the trust. And in directing that the property be sold by the trustee, the donor hereby declares that any beneficiary occupying any real property owned by the trust shall be considered a tenant in sufferance. Any beneficiary who fails to move after 30-day notice to quit shall be subject to eviction. That beneficiary is liable for use and occupancy. So I don't see that simply by them unanimously agreeing that the property shall not be sold, they get to go on living there rent-free. What I do see is that 5.04 and 5.05 provide for distribution of shares of the principal of the trust remaining after the payment is made to James. So if they want anything to be distributed to them, they can affect the form of what it is by agreeing not to sell the property, but they don't get anything until under 5.05 until after after James gets the distribution. Because 5.04 says the balance of the remaining trust principal shall be divided and allocated into shares for Mark and Keith. And that's after the payment to James.
So if, by that reading, Your Honor, that renders 509 completely superfluous, okay? Because if you sell the property...
Why is it superfluous? It says, sell the property unless these two people agree not to. So we can do that. And she's saying, the default is sell the property immediately. And there's one circumstance in which you don't necessarily have to sell the property immediately. How has that become superfluous if we interpret this as requiring the other provisions of the trust to be enforced?
So if the property is sold under Section 503 and 504, by the time you get to 509, dealing with the right to buy out the property and this right to unanimously agree to not sell the property's already been sold. If what you're suggesting, Your Honor, and what the plaintiff has suggested, is that this trust should be read to say that 503 and 504 encompasses selling the property, considering the property as principal, which I disagree with. But if you consider the property as principal, distributed under 503 and 504, the trust could end right there. What is the purpose of 509 in that
Because
instance?
that wouldn't tell you that the immediate thing to do as a trustee is to sell the property and to give right of first refusal to these two people. I don't understand why it's superfluous.
Because...
It does something. It says sell the property immediately and give first refusal to these two people.
Unless otherwise unanimously agreed by James and Keith, which they have.
And I agree. I mean, it's not for me to agree or disagree with the language of the trust. If both Keith and Mark agree not to sell the property, it will not be sold. But that doesn't insulate them from the incentives created by other parts of the trust. And if they can't get a distribution until James is paid his $50,000, and the only way to make the distribution is to allow the property to be sold, then either Keith or Mark, in their capacity as beneficiaries, would say to themselves, hey, I'm not going to get anything until James is paid. So I'm not going to agree not to sell the property because it looks like that's the only way to pay James. And maybe I can buy the property because I still have a right of first refusal. Maybe I can go borrow the $50,000, pay James with it, then buy the property using my right of first refusal. Or maybe the two siblings together can do that.
So I guess that, to me, is rendering this clause, unless they otherwise unanimously agree, superfluous. Because if they can agree to not sell the property, they don't have to sell the property.
Right, but doesn't that produce a stalemate?
It's a stalemate, but it's resolved by Keith's view of this trust, which is that this trust was created by his grandmother, who went to an attorney and said, at 90 years old, I'm going to save up $1,000 a month on my Social Security for 5 years, and that's going to result in the $50,000 that's supposed to go under the terms of this trust.
So,
and the intent with the property, go ahead.
5.09 does say that the beneficiaries, if they live there, are liable for use and occupancy. So conceivably, if Mark and Keith agree not to sell the property, then the trustee has a fiduciary duty to collect rent. And maybe once that the accumulated rent gets to be $50,000, then James can be paid, and then the balance of the trust, which is still the ownership of the property, can be distributed to Keith and Mark.
And Mark and Keith have lived at the house since 2020, right? Have they paid rent?
They have lived there, no one has paid rent. I'm not seeing where Your Honor is referring to the need to pay rent.
Bottom of page 100, or page 9 of the trust document. It's towards the end of 5.09. Paragraph begins, notwithstanding the foregoing. Oh, I'm sorry, that was the preceding page. Yeah, it's right before.
So, Your Honor, I think this entire paragraph is dealing with the recalcitrant beneficiary where there's not an agreement, where you've got one beneficiary who's saying, I'm not going to move out, even though we haven't unanimously agreed. And it's saying, well, in that case, you can do all these things. You can charge damages, you can charge attorney's fees, you can charge rent for that beneficiary being there. This entire paragraph relates to a recalcitrant beneficiary where there isn't an agreement by the two of them to not sell the property. And I would further add that this first sentence of 509 modifies everything that comes after it.
Well, what right do they have to live in the house? It hasn't been distributed to them.
The right under 509, where they can unanimously agree to continue residing there. And that's consistent with what Mary Larson's intent was when she created.
Well, it doesn't say that. It says they can unanimously agree not to sell it immediately.
But they're not tenants. But they're not tenants of the trust.
It doesn't say they cannot sell immediately. It says they do not have to sell at all. They can agree otherwise.
Where does it say that? Unless otherwise unanimously agreed by James Mark Devine and Keith Devine, if then living, shall sell and convert into money any real property the trustee may own or have an interest in. That's what it says.
Well, I think it's saying that they can modify this entire.
Let me ask you this. You seem to be appealing the judge's finding that the trust has to pay the plaintiff $50,000.
That's correct, Your Honor.
How can you do that when you agreed to partial summary judgment? Forget the judicial estoppel thing, just as a matter of preservation. How can you appeal a partial summary judgment that you affirmatively asked the judge to issue?
Because the basis for asking for that relief was based on the advice given by prior counsel, Ann Cushing, who said, which was contradicted by another attorney in that firm. We had contradictory advice given. One was no cash, no need to pay the $50,000. That's attorney James Casiello. He leaves the firm, attorney Ann Cushing takes over the case and says, no, something different, you need to get a loan and pay this $50,000. So we have contrary advice from the same firm given to these two individuals. That causes a split between the two of them. Keith is looking at this. There's been a Superior Court case filed. He's looking at the possibility of massive attorney's fees, which has been extremely prescient. And he says, I want to follow Attorney Ann Cushing's advice, try to get a loan on this. So when he's talking about paying this, he's talking about getting a loan to pay that. That's what he means by that. He never anywhere said sell the property.
You wrote a document asking the judge to issue you signed it, asking the judge to issue the very ruling that you're now challenging. Why can you do that? Why can you challenge it now?
So, Your Honor, because at oral argument, I explained this scenario, and I went into it as to why attorney's fees shouldn't be ordered, as to why there wasn't a breach. And the trial court incorporated that argument into his summary judgment ruling, where he said that sale may conflict with the terms of 509. And really the hope was that they could simply get a loan that would resolve this case. So, and he did try to do that, and then he finds out that they can't get a loan. So now we're left with summary judgment where there's been a breach of not getting a loan on the property, which we later find out is impossible to do. So you now have a finding that there's been a breach, but the underlying reason for that finding of a breach is impossible.
I understand why you changed your mind, but my question is, how can you tell a judge to do something and then appeal them for doing it?
Because I did not ask for the sale of the property. I asked for the opportunity to have them have Mark removed as trustee, have Keith have the ability to go and attempt to get a loan, which is what he did. Simply, it couldn't be done, and the judge in summary judgment recognized that sale would conflict with 509. So,
oh no, he didn't do that. He didn't say that. He didn't say it would conflict with 509. He said he didn't reach that issue, perhaps, but he said there were many alternatives that you could raise the money. But in any event, the second judge said this issue was decided at the summary judgment ruling, and everything that you filed since then is wholly unnecessary. Do you disagree with that?
I do disagree with that because the summary judgment order was based on the assumption that a loan could be obtained. That was the entire purpose of this. A loan couldn't be obtained. So now we have to revisit that. And the trial court never revisited the fact that you could not get a loan. And it never revisited the fact that the summary judgment order does state that outright sale may conflict with Section 509. And that wasn't revisited in the final judgment. It just steamrolled right over that.
Clarify what Judge Wilkins said. Because he didn't say, he said, there are at least two alternatives to sale of the property to satisfy the trustees, there was two then, obligation to pay Larson, refinancing the property and obtaining a home equity loan. That was his conclusion. Page 219 of the record appendix.
I just one final question, which is why wasn't this dispute arbitrated?
That is a good question. I did see that clause. This was filed by the plaintiff in this court, and that wasn't an issue that was raised at the time that it was filed.
Okay. All right. Thank you for your argument.
Thank you, Your Honors.
We'll hear from Mr. Jutras, is it?
Yes, Your Honor.
Yes.
May it please the court, Bob Jutras. I represent Jim Larson. Jim is the sole surviving child of Mary Larson. I'll address first the issues which the panel of justices were addressing, the language of the trust. It's clear, Section 0.2, the trustee shall divide and allocate the remaining principal and undistributed income as follows. Then you have section .03, $50,000 to the donor's son, James Larson. That's clearly a clear and unambiguous command of a $50,000 device to her son. And this is critical. Section .04, the balance of the remaining trust principal. The balance of the remaining trust principal. It's clear that the donor, Jim's mother, Mary, wanted Jim to get the first $50,000. It's an unconditional devise. And then what's left is the 2 shares go to Mark and Keith. Section .09 throughout the lower court litigation continues to come up, and it's been argued that Mark and Keith have an unrestricted ability to just say, we're never going to sell the property and therefore we never have to pay you. And that's not what was found by the lower court. The lower court found that in their fiduciary capacity, they had an obligation to make this unconditional $50,000 devise to James.
Do you I think your brother drew this distinction between Keith as the trustee and Keith as the beneficiary, and that Keith as the beneficiary has the right, along with Mark, to refuse to sell, even though Keith as trustee has a fiduciary obligation to your client. Do you agree with that distinction, or is that...
I understand the distinction, but I don't think it matters, because he is the sole trustee right now. When he was a co-trustee with Mark, and as you saw from the record, Mark's sued me once and probably will sue me again. He's a very difficult individual, as you may have seen from some of the judge's references in his orders and from the docket. And he would not agree to make the distributions to James. There are at least 6 instances throughout the case where affidavits were filed, where oppositions were filed, in which Keith agreed that the $50,000 payment should be made to James. It was only after Mark we finally had him removed as a co-trustee, and the point was to then give Keith the ability to try to get a loan or to try to figure something out as to how to make the payment. Your Honor, your comment about the arbitration, how this case should have been resolved 3 years ago is we should have just had a non-judicial settlement agreement. The interests in the trust could have be conveyed out to Mark and Keith, subject to a mortgage to James. Then they could have gotten an equity loan or a mortgage. And this case never would have had to be brought. We waited 13 months after Mary's death before we brought the claim, trying to get this resolved. But Mark and Keith would not agree to a non-judicial settlement agreement to bring this matter to closure. Now you've seen that legal fees are over $100,000 on a $50,000 claim, that this never should have gone this far.
Do you believe that Keith and Mark owe rent for living in the property?
Yes.
And
yes.
Have they paid?
They never have.
They've never paid that rent. They've been living there since 2020?
Well, at least Mark. At some point, I believe Keith moved out. Mark, I believe, is still living there from what I understand.
Do they have a property interest in the interest?
No, they don't. They have no property interest whatsoever.
What is their status then?
They only have a beneficial interest in the trust. It's clear that the trust is the owner of the property. That language, Your Honor, that you cited in section 5.09 about them not having an interest as tenants in common, joint tenants, and then if there is an eviction, it's a tenancy at sufferance. So right now, that's where we stand. Right now, Keith is the sole trustee. As you know, there's a whole body of case law in Massachusetts which deals with breaches of trust, breaches of fiduciary duty. The Uniform Trust Code has a number of remedies for that type of behavior, and the lower court found the unconditional requirement to make the payment based on their fiduciary duty. With respect to the legal fees, Your Honor, the Brody case and the The Brody case and the Bourneval case, which are cited in our brief, those are cases which are talking about remedies for breaches of fiduciary duties by trustees, and when you have a prevailing beneficiary who has prevailed. And what these cases discussed is when a breach of fiduciary duty involves the denial of a party's reasonable expectation of a benefit, the remedy should, to the extent possible, restore the benefit reasonably expected but not received because of the fiduciary breach. And then there are other cases which discuss how do you make that person whole. Well, Mr. Larson, who's an older gentleman in poor health, has now paid about $70,000 in legal fees, and I've deferred another $30,000 or $40,000 of legal fees as a result of this appeal. And so the trial court obviously found that the only way to make Mr. Larson whole was to award his legal fees, because then he would get his expectancy, which was his $50,000 bequest that should have been easily resolved with a non-judicial settlement agreement 3 years ago. So we would ask that the court deny the appeal, uphold the lower court's decision in finding that in their fiduciary capacity had an obligation to make the distribution, uphold the discretion of the trial court in awarding the legal fees and the prejudgment interest as well, which is part of the order. And also, if the court finds that the appeal is frivolous, we will be filing a petition for attorney's fees under Rule 25, because it's our position that all of these issues have been addressed below. They've been raised repeatedly. The whole issue about redemption, and which you saw in the briefs, abatement and redemption, have never applied in this case. This is really a demonstrative device. When a trust leaves money without a specific fund, it's referred to as a demonstrative device. When there's not money in the trust, the demonstrative device becomes a general device, which drops into the residuary. It has always been clear that the real estate in this case, based upon the unambiguous language of the trust, is the trust corpus and the trust principal. It's the same thing. So that property is subject to the judgment and the $50,000 devise. And throughout this litigation, that fact has been consistently ignored by Mark and Keith, which has required this level of litigation and motion practice trying to compel a payment. But now we're at the point where now if the court denies the appeal, now we have a judgment, and either there'll be some sort of settlement or there'll be a sheriff's sale, or the property will be sold. There's still options, and it was always our position to try to not to have to get a judgment, go through all that cost, and then proceed with a sheriff's sale, because that doesn't benefit Mark and Keith, because a sheriff's sale obviously is not going to bring as much money as a on-the-market sale. We've proposed all kinds of solutions over the last 3 years, and none of them have been accepted. And here we are in the appeals court.
Can I ask you a question? Did you raise judicial estoppel in the lower court? I didn't see it.
We did not, because it didn't really come out, Your Honor, until after the judge awarded the entry of final judgment in March of 2022. I forget whether it's 21 or 22. I think it's 22, Your Honor. And it's
23.
23, okay, 23, thank you. And so it was not raised because at that point there still wasn't a, well, I don't recall right now if counsel for the appellant was raising some of these. It was, well, specifically, I don't recall if they challenged the original summary judgment order in 2021, which was the order that said in their fiduciary capacity they have an obligation to make the $50,000 payment. I don't remember if they challenged that at that point or just as part of the appeal. I don't recall.
All right, seeing no further questions, we thank you both for your arguments.
Thank you.
And our last case of the day is number 23P919, Brad Richard versus Tricia Richard. This is a partly impounded case, so I just remind the council to stay within the scope of what's impounded. And Mr. Bodanza?
Yes.
All right, whenever you're ready.
May it please the court, and good afternoon. Attorney David Bodanza for the defendant appellant. I think this appeal is very, very straightforward and simple. The trial judge committed an error of law in excluding a chosen action from consideration from marital division via her pretrial order first. She focused only on custody, parenting time, and child support. The parties had lived in a property in Templeton.
Can I interrupt you right there?
Sure.
And ask you, you say she excluded a chosen action,
Yeah.
meaning, I guess, either an unasserted claim or a pending claim. But as I understand the record, the wife, by the time of trial, had already filed a suit in district court, subsequently moved to superior court, to obtain against the husband and the husband's mother to either enforce this agreement, this rent-to-own agreement, or to somehow obtain a constructive trust or a resulting trust. I'm not quite sure what relief the wife is seeking, but it was the wife who had the pending claim at the time. Why wasn't that listed as a chosen action on the wife's financial statement? I'm assuming it wasn't because we don't have the financial statement that was offered prior to trial.
I don't know the answer to whether or not it was on the financial statement, but I do know that trial counsel did file a motion in limine to amend the pretrial order to widen the scope of the trial to include that resulting trust claim, which was denied. And so that was not ever...
Well, that's not exactly what she did. All right. I don't remember it was to add the division of the parties' equitable interest in the real estate, not the interest in the lawsuit.
I think that's probably a distinction without a difference, with all due respect. But yeah, that's it. I mean...
And what confuses me is the judge seems to try to decide, even though she excluded it, whether there is an equitable interest, instead of just saying who owns the result of the lawsuit. But he didn't say add the result of the lawsuit to what's being decided. So does that explain why the judge is sort of missing the point?
No, I think the judge was clear why she missed the point. She indicated that the property was not titled in the name of the parties, therefore it would not be considered at trial. And that is the issue I bring
Where
before
did
you.
she give her rationale for denying the motion in limine?
I believe that, I don't know if she actually rendered any opinion other than a denial on the motion in limine, but I believe that she put that in her findings. Number 57, finding 57 indicates the court finds that the residence located in Templeton is not a marital asset and stands in the name of the children's paternal grandmother.
But does that explain why she denied the motion in limine, which you're saying kept out evidence that it should be treated as a marital asset?
Yeah, I think that does. I think her thinking all along was it wasn't titled in the name of these parties, therefore it's not fair game at the trial. I'm not going to consider that. And my client through his previous counsel also filed a motion post-judgment to bring the issue up again, to amend the findings of fact and the rationale, and provided an offer of proof at that time, and that was denied. So the argument that...
Let me ask you this. At trial, your predecessor suggested that there was a signed agreement between the parties saying that the proceeds from this lawsuit would be shared equally. Is that not true?
I don't recall.
We're trying to get something in, and it sounded like that was what it said. The judge wouldn't let it in.
Yeah, I don't recall that. I knew that the agreement between the parties and the mother-in-law was verbal and was nearly fully performed, meaning that I think the parties paid $70,000 and there was only $3,300 left for them to complete what the agreement was.
Would there be a statute of frauds issue with respect to any effort to enforce that oral agreement?
Well, I think you get over that with a resulting trust and also the performance by the parties. They kept a ledger of the payments that were made, and the ledger was attached. And so they're all...
Of course, the ledger doesn't say whether it's for rent or for purchase, at least not that I can see.
Yeah, I don't know if that distinction was drawn finally.
Larger question, the judge's decision, findings, rationale, judgment, didn't seem to address property division at all, other than to say the house isn't a marital asset. So I'm wondering, are we missing something? And I noticed that it incorporates a partial separation agreement, but I don't find that partial separation agreement anywhere in the record.
I think the partial separation agreement was attached to the judgment as an exhibit. I think she incorporated that as an exhibit, the judgment of divorce, which I think appears as page 38 in my brief.
Oh, it may be at Record Appendix 16 in the brief. Yeah, okay.
Yeah. And so whatever property issues that they were, I think were taken care of by that. But again, that did not extend to the real estate. And so we know that from Canisius versus Morgenstern that it's an error of law. It's a question of law that the probate court had before it, and the court today is in a position to address that same issue.
So the partial separation agreement at page, Record Appendix 1, page 17, paragraph 8, after having gone through, the wife gets the nitro boat and the skidoo, says all other personal property has been divided to the satisfaction of the parties. All right, so it doesn't address real property.
Right. And so we know...
They didn't own real property. They had an interest. You're saying an interest.
Yeah, an interest.
How could that be settled without the mother-in-law as a party? And if the judge had included it as an asset for purposes of equitable division, wouldn't that effectively be compelling the husband to go initiate litigation in order to collect on that?
I think the approach is the if and when received basis. So basically, I think it would be incumbent upon the wife, because of the allegiances here, to go out and do what she did, file a lawsuit to get the mother-in-law to convey. But what the court should have done is that if and when received, the division of this real estate is thus and so. as a percentage, we would probably
Couldn't the
think.
judgment be subsequently amended if there were that litigation and there were an ascertainment of property rights? I mean, it
could've-
seems a very strange thing to sort of say, wow, this judgment should have acknowledged the possibility of a future litigation outcome as opposed to going back and amending it later.
I remember the case, I think it's Canisius, I think I'm right, where an attorney's spouse's interest in a contingent fee agreement was divisible. So it's kind of like there's future recoveries that are considered by the probate court all the time. And I think the ability to amend under Rule 52, if I'm correct, is only 10 days after the judgment. And because it's a property division, modification would not attach to that because, as we know, property division is final upon the judgment issuing.
So do I understand correctly on this issue, all you want us to do is tell the judge, decide how the proceeds of this lawsuit, if any, are going to be split up?
Precisely.
That's it?
Right. Precisely. The second issue is a little...
Could
sorry.
that affect the division of the other property?
Maybe. That's a great point, Your Honor. Maybe. So maybe vacate the property division completely. That's a good point.
Is a unasserted, unliquidated claim a chosen action? Because from all that appeared to the judge on the record, at the time the wife filed her motion in limine, this was just the wife saying, hey, we had an agreement. The wife did not disclose that she had filed or was about to file a lawsuit about it. No amount attached to the value of the claim. And the cases that you've cited about dividing interests in the proceeds of pending lawsuits involves pending lawsuits or pending claims that were liquidated. This seems to be quite different than that. Why couldn't the judge say to the wife, in essence, if you have an interest in this house, you got to litigate that with the mother-in-law. And obviously the husband would have to be a party to that. He's a necessary party. He has an interest in it probably to the same extent that you do. I'm not going to get into that. You haven't given me enough basis to resolve it. And this Superior Court claim is pending. Work it out there.
That would be probably a more preferable ending because, and I'm not trying to educate anybody that probably needs to be educated, is that you run into a potential res judicata, collateral estoppel type of argument by husband.
Has that been asserted?
I don't know.
And would that apply where the wife attempted to litigate it in the divorce action and was not permitted to?
That's the question, isn't it? That's the $300,000 question, perhaps. And I'm just speaking,
I'm sorry, have you addressed the stipulation on page 18 of the record appendix that that property division, nothing herein shall be intended to divide an equitable interest or liability that may or may not exist in connection with the former marital home? How does that affect this dispute?
Well, maybe that does preserve this problem from a res judicata argument, perhaps.
So walk me through this. If nothing happens, if we just affirm and your client wins this lawsuit, won't you just get all the money?
I sincerely doubt it, but...
Without a division, what would the claim of the husband, who's a defendant in that lawsuit, be to the money?
Yeah, he would have a claim. He's a party to it. So there would be probably addressed in equity by the Superior Court, I'm assuming.
That's what you're saying. The judge would probably divide the proceeds between the two of them.
I would imagine. Yeah.
So another reason that issue preclusion or claim preclusion might not apply in the Superior Court is that the mother wasn't a party there.
The mother wasn't a party to?
In the divorce action.
Right, but it could be used offensively by father, perhaps.
But you don't know whether that's happened in the Superior Court action?
I don't. I'm sorry, but I don't.
And the judge wasn't actually aware of the other action at any time before the post-argument filing, and perhaps not even from there, because there it is mentioned in one paragraph at the end of a 4-page document. Leaving this finding to stand would be prejudicial to the defendant in the matter pending before the Gardner District Court. No argument, no statement about what that matter was that was pending in the Gardner District Court. At any time, was the judge put on notice that there is a claim pending for the equitable interest in the house?
I don't know. I don't know the answer to that.
So was it an abuse of discretion for the judge to keep evidence on this issue out when the judge had no reason, nothing before her indicating that there was a pending claim, what the value of the claim was, what the potential defenses to the claim were?
Whether it was a claim that was in court or a claim that wasn't in court, I think we reached the same conclusion, that the judge concluded that the property interest, whatever it was not before the court because it wasn't titled in the name of the parties. And that's the era of law that we have.
Okay, but we have nowhere that the judge says, I'm not allowing evidence in because the property isn't titled in the name of the parties.
I think we do. I think that's a finding that I referred to earlier. Finding number...
That's a finding, but that's not an explanation of why she denied the motion in limine. That's a finding based on the evidence that she allowed in. It doesn't explain why she kept evidence of the supposed agreement out.
Yeah, but the pretrial order says, and typically this is what's happening in the probate courts, is that the pretrial order says this is the trial time you get and this is what the issues are at trial. And conspicuously absent from those issues was property division. So counsel, I think correctly, went in limine to amend that pretrial order to say, Judge, I'd like you to consider property division as well. And that was denied. So ipso facto, I think it's pretty clear that she wasn't going to hear that for that reason.
Okay. All right, see no further questions. Thank you for your argument. And we'll hear from Ms. Pollack for the husband.
If it please the court, Donna Richard Pollack for the appellee. With regards to custody, and I know we didn't really touch on that during counsel's argument, I know that they're arguing that the court did not consider all the relevant factors, but I think from the findings, it's very clear that the court considered many factors when they decided custody. Rosenberg is cited as a case that would warrant sending it back down, the issue of custody, to the lower court. But when you look at the judge's findings and you review the record, there's ample evidence of why it's in the best interest of the children to be in the father's care. The father had been the primary custodian for the past 3 years prior to the divorce because of mother's addictions, which were sending her in and out of rehabs. And there was ample evidence about her inability to care for the children. I know in my brief I cited repeatedly evidence that had come in. Most of it came in through her own medical records of her inability to remain sober, her drinking while the children were in her care, and her denials to the court which made her not credible, including a specific denial in which the father alleged that he had to go pick the children up because she was intoxicated. She told the court, she came to court, was able to test clean 5 days later, but then told the court that she hadn't been drinking. When her medical records were obtained, it was clear that she had been drinking. Repeatedly, over and over in her medical records, she says she's a daily drinker, which meant that she was drinking while she had the children in her care and that she was drinking to in excess. In one statement, she says she was drinking 20 nips a day. In another statement, she says she was drinking 2 bottles of wine per day. During those time periods, there were times when she was caring for the children. So she was drinking 20 nips while the children were in her care. Father had to go retrieve the children from her care. And she was drinking 2 bottles of wine a day for 4 weeks, and periodically the children were in her care. But she continued to deny that the children were in her care, even though it had been apparent. She denied to the court that she was drinking when father went to pick him up, and her medical record said she had a very high alcohol level and she had drank 20 nips that day. It wasn't only that, but the father was there. The court considered. Mother says that the court didn't consider his drug use or alcohol use, and it absolutely did. It's in the findings. It's in the judge's specific findings, so she considered them. Those were all factors that were relevant, and more importantly, while being in the father's care for the past 3 years, the father was meeting the emotional needs of the children, the academic needs of the children, and the social needs of the children. And probably most paramount what the father was doing was he continued to promote a relationship between the children and the mother. He didn't knock her out of the children's lives. When he thought she was sober, he increased the time with the mother. When he thought she was drinking, he decreased the time. He did exactly what the court would want him to do. It's unfortunate, but the children have been in his care for 3 years. He was the primary caretaker. He wasn't a seat holder for mom to come back or a placeholder. He was the parent, and he was parenting, and he was parenting responsibly. So as far as custody goes, I think the court went to great lengths to consider all of the factors that were there for that.
So, turning back to the house issue, has the husband asserted, or does he intend to assert in the Superior Court litigation, any kind of claim preclusion or issue preclusion defense?
I'm not clear about whether or not that's been whether or not that has been pled in Superior Court.
Do you agree that that's relevant to whether it should have been decided here? I mean, if it had to be decided here or would be barred for all time, then wouldn't it have been better to decide it here, and maybe shouldn't we consider remanding for that purpose? Whereas if it could all be decided in Superior Court.
My thought is that it can be all decided in Superior Court. I think that their contributions are going to be considered in Superior Court. I think in Superior Court it's more of a contract action. I don't think that there's a constructive trust. When I read the cases on constructive trust, they talk about who gave the consideration for the purchase of the home, and in this case, the mother gave the consideration. The mother paid the entire home out of her savings. This wasn't what they were talking.
Husband's mother.
The husband's mother, yes, I'm sorry. I'll try to keep wife, husband, mother, his mother. But I believe that those cases are distinguishable because in those cases they talk about the purchaser giving money but putting the house in somebody else's name, whereby the constructive trust is created. But that is not the situation here. The husband's mother put forth the entire purchase price, which is in the submissions by counsel in the transcripts from the other litigation, and nobody disputed that. So I don't think that's a constructive trust that's created here.
Is there any prejudice to the husband if the dispute proceeds in Superior Court, rather than hypothetically us remanding to have this litigated in the divorce action?
I was thinking about that as you were asking counsel questions. I would think that the difficulty may be in the husband defending in one sense, but then trying to say in the other sense, well, if wife wins, I certainly should have a share of that. So I think there is some potential difficulty there.
But is it prejudice? Is it legal prejudice? It might be awkward between the husband and his mother, but
I think, I'm not sure if it's prejudice, but I will say that I don't think it should be a windfall for the wife if she prevails in Superior Court. It was our understanding and our hope that the Superior Court would look at each person's interest. But you're correct. On the one hand, he's defending. In the other hand, he's saying, but if she wins, it shouldn't all be hers.
This is what I don't get about this case. We have this Superior Court lawsuit. Why wouldn't everyone want the judge to tell us how to divide the proceeds if that lawsuit succeeds? I don't know why you're opposing that.
Well, I can tell you, I know that you asked whether or not the court knew about the lawsuit, and I believe that from my memory, the court did, that was one of the issues, that there was a pending lawsuit in Superior Court, and I believe that issue was brought up.
Do you know where? Because the only mention of a lawsuit that I've found is in the concise statement of fact and law attached to one of the post-trial motions, and it's at Record Appendix 1, page 93. There is a very brief paragraph that provides no specifics about a case pending in the Gardner District Court.
I'm not sure if it was in the wife's motion in limine, but I believe it was discussed. I believe orally it was discussed. That's to the best of my recollection.
You can find it. We would like to know.
I will look for that, but I'm not positive
Either party
that was in there. Because
So why are you against the judge determining how you're going to share the proceeds of this lawsuit?
I think it's our position that the Superior Court judge can make the entire determination about what interest, if anybody, has in that.
The other thing that sort of puzzles me here is I don't understand how the judge can specifically exclude this issue from trial and then make two factual findings about it.
I believe that, from what I recall from the motion hearings that we're having, she felt that the Superior Court would decide all of the issues. I think the findings were because the wife presented evidence on it during the hearing. The wife questioned the husband about the written agreement between the husband and wife. I know that we felt that was sort of negotiations, but he was questioned about it. He was questioned about whether there was an oral agreement between his mother and he, and whether or not they had completed that agreement, whether or not payments were being made to his mother, how those payments were being made. So I think that the judge made findings that were just consistent with the evidence that the wife presented. The other reason why I believe that the court probably put forth those findings is because specifically in the wife's proposed findings, she was asking for findings on that. She was asking for specific findings about the marital home, and so I think that's why the judge gave some findings on the marital home.
So I see that the wife's motion to amend asked to strike finding of fact 56 regarding the house, but not to amend it, not to add anything, not to amend the judgment to include the house as an asset and divide it.
Just to strike the particular finding,
So what would be the effect of striking 56?
Well, I think that, in essence, evidence was presented to a court already on that matter, and the court made a finding. It was presented by the wife. I'm not quite clear why the wife was presenting evidence if she didn't want evidence on this. I mean, the husband certainly wasn't presenting evidence on the marital home. It was the wife who was presenting it through the husband, and then...
Maybe she wanted it stricken to avoid any preclusive effect in the Superior Court litigation?
I would imagine that is the basis for her wanting to strike it.
Do you have, what's your understanding of why the judge at Record Appendix 3, page 40 in the transcript, refused to admit the document that purportedly had the agreement regarding the house?
That was because, my understanding is that was because what was being presented was in a, was it the agreement or the ledger?
It was it was referred to as the agreement. Record Appendix 3, page...
If it was the agreement that was being presented, I imagine that it was because I believe that the husband had objected, indicating that any agreement that was signed at that time was part of marital negotiation, divorce negotiations. I believe that's the basis from my recollection. With regard to the ledger, that was not admitted because nobody could authenticate it. The husband didn't recognize the ledger, and they didn't ask the wife about it, and they didn't present the husband's mother to authenticate the ledger. So I believe that's why the ledger didn't come in.
And you mentioned in your brief the party stipulation that nothing herein shall be intended to divide an equitable interest or liability that may or may not exist in connection with a marital home. What was the purpose of that stipulation?
I believe because we were creating a property agreement and the wife wanted to ensure that that wasn't going to be used to stop any division of the home, indicating that there had been a full agreement for division of assets. So it was more to just ensure that neither party would be prejudiced by the property settlement that was put in place.
At the time this agreement was signed, I thought it was a 2019 agreement?
Correct.
Was the divorce action hadn't already been filed?
Correct. The divorce action had not been filed. They were just contemplating that they were separating and that they were going to get divorced. In fact, that was where the husband had made many provisions for the wife with regards to assisting her in the move out, in their separation, and they had begun dividing property.
So is this the, in the husband's, or sorry, in the wife's concise statement together with her post-trial motion, she says that the husband signed an affidavit on May 4th of 2020 saying, we signed an agreement in 2019 dividing the house and all of its contents.
I'm honestly not sure what that's referring to unless she's referring to that actual document. Could you just repeat that to me one more time?
Yeah, this is on Record Appendix 1, page 91. In the wife's post-trial motion, she says, the husband signed an affidavit on May 4th of 2020 that said, we signed an agreement in 2019 dividing the house and all of its contents.
I don't know what that's referring to. I'm not sure what that's referring to.
Okay. All right.
Unless...
Further questions? Seeing none. All right.
Thank
you both for your arguments. That concludes our arguments for today, and we will be in recess, or we will adjourn, and we will come out shortly afterward to talk to the Committee for Public Counsel Services summer interns who are here. So if you folks will just be patient, we'll be with you.